Peace, 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 everyone. How's everybody doing? Let me pull up the. That's going. Okay. Okay, and y'all can look in the chat. Y'all can type in the chat. Take some time to look at the screen. I typed a piece down there. Y'all can see, find where it says chat. That lets you type questions and everything in, or you can raise your hand if you have a question. Hit the hand button. Okay. Okay, let's get started. Let me make sure everything's recording. Okay. I want to welcome everybody in. First thing I want to say is um, I want y'all to, give me some feedback on the website. All criticisms are welcome. I am, adding things. Don't think for a second everything is on there. I know people say, well, what about this? And I need a video for that. I am adding the videos. I'm doing like 50 different things at once. Videos will be added every day. So just log in every day. You're going to see something new. And we haven't been having webinars, but y'all are about to get sick of me having webinars because I'm about to do webinars 3-4 times a week. So you're gonna get, the webinar is gonna be old news for you after a while. All right. So because I got everything set up, looks like everything is rolling good. And that's about it, just as far as announcements I have. Any feedback on the website? Somebody give me some feedback. How about Tanisha Johnson? Open up your mic.
Hi, thank you, Yusef, for hearing me. Actually, I think the website is pretty awesome and it's coming along great. I like all of the information that you've got on there. My question was, I noticed that a lot of files are getting deleted from the Dropbox. Are you just migrating everything from Dropbox to the site, and we're no
That,
longer going to be using
that
it?
that's correct. I'm
Oh,
migrating everything from Dropbox to the site. That's right.
all right,
You'll still have everything that was in the Dropbox. It's just going to be organized more so on the site. So, but everything that was in that Dropbox will be on the site.
okay, cool. And it's coming along great. I mean, I go on every single day. I'm reading new things. I'm listening to the audio files. It's amazing. It's a lot of stuff on there, a lot of information.
That's a lot more coming. I haven't even put up the templates yet, and I'm putting up I put up a business section so you can do an online business, and I have like a ton of plugins paid for, all kind of stuff. And I'm also doing some instructional videos, show y'all how to put up your own websites and start your own business. And I'm gonna add a feature on here where you can sell your own stuff from this website too. If you have something to sell, I'm gonna be making that a feature available too. So it's gonna be chock full of a lot of different things um, that y'all haven't seen anything yet. I just got the foundation is built pretty sound. I'm satisfied with it. So now I'm going to take it to the next level.
Okay, well, thank you very much for all of your hard work and everything you're putting into this. Your dedication is amazing. Thank you.
You're welcome. You're welcome, and thank you for your support. I appreciate you. All right. Anyone else? Did y'all just come to listen tonight? Because I wanted to take some questions first, and then I'm going to get into some discussions about. I kind of wanted to go into a little bit on the secure party process and discharge of debt, uh, foreclosure. I know some people had some questions about some foreclosure type things. I was going to start off tonight talking a little bit about foreclosure and unlawful detainers and things of that nature, and how to fight those in court. I'm going to be doing a lot of videos on court action too. Um, I believe it or not, yes, I have a lot of experience in writing motions, writing actions, and a lot of things that y'all probably never even see me do. I'm going to be demonstrating on this website uh, a lot, so people can really understand the full extent of how deep I've been into this. I'm kind of satisfied that it's locked down. I didn't want my stuff floating around the internet, and things like that. So I'm pretty comfortable with where it's at. So now I can just start to roll a little bit more. Let me open up the mic. Quentin Riley, real quick, has his hands up.
What's going on, Yusef?
Hey, what's happening? What's going on, man?
Man, the website uh, look great, man. I mean, you put in a lot of work, as everybody can see, and I mean, it's awesome, man.
Thank you. I appreciate it.
Uh,
Hold on for a second.
that's all I have, man. I mean, this is just, hey, man, I appreciate you, bro. I mean, I can't say no more, man. Speechless. Uh,
Hey, hold on, y'all. I apologize about that. Come on, go ahead.
yeah, man, I
He's
can't.
knocking on my door, but go ahead.
Yeah, I can't say no more, man. I'm speechless, man. I mean, I appreciate you from the bottom to the heart, man. And I mean, I speechless, bro. I mean, you can't get no better than this, man.
Hey, like I said, It's more coming. Y'all just be patient. I just got up to stuff just to whet your appetite. It's gonna be something added every day. All my stuff that I want to put on there, I don't have on there yet. So it's a lot of stuff I got to put up. I got to put up the templates, for y'all to file stuff. Videos on that. I got to finish the secure party. I got to do all my webinars for my training videos for the trust. It's a lot of stuff. It's a lot of stuff. I'm gonna be working probably every day for the next 3 months, putting stuff on here until it
Right,
gets to the point where I want it to be at. So that's why I'm in overdrive with the I'm going to overdrive with the webinars now. So because I'm at that point now, I got everything I want. It's set up the way I want it to be set up. It's running smooth. It took me a long time to get to this point. People don't understand. I've been working 18 hours a day just to get it to this point, but the work paid off, and now I'm ready to put the content on here. So you're going to be, trust me, it's going to be. I'm always a person that strives to give you more value than what you paid for.
right,
I
right.
like people. I like people feel like they got more than what they paid for. So that's what I'm looking to do.
That's it's definitely that. I mean, ain't no ifs, ands, or buts about it. Uh, like I say, man, I'm here if you need me too. So, uh,
All right, yeah, and I'm gonna be contacting you about some stuff. Guys, I see you got your stuff down too. You kind of understand. I put these websites together now.
yeah, man. But the thing about it, I keep. I mean, I see one thing, then I see something else, and I start all over again.
That's what you got to get away from, because what it is okay. I see the questions popping up. I see y'all's questions, so I'll start answering your questions. But that's what it is with websites, man. There's so many tools out there, so many different things. It's gonna take you a little while. I've been already went through that. I sifted through the good stuff, and I know what the bad stuff is, and I know what the pitfalls are. Uh, so I got what I want now. So I know, I know how to, how I want it set up and everything now. But don't get distracted. Stay focused on what it is that you're trying to do and keep it simple because you can get into some complexities with all of this stuff and you end up wasting time and pissing people off. That's what's going to happen. People are like, man, I'm tired of Yusuf. He changing this, he changing that. You know, call me when you get through with this shit. All
And
right,
you
man.
like you heard of Ring Central?
I think I've heard of it. Ring Central. You
And
know,
I got the ultimate plan. When I say it's great, like you do webinars. It's like a virtual office.
yeah, I got one. I forgot the name of it right now, but mine is it's going to run through YouTube, and because see, you have to understand the marketing aspect of all your business too. And YouTube is definitely a good platform for that. But it's going to connect with YouTube, and people can register and come to the website through YouTube and so forth. It's going to be pretty awesome. I'm going to do that primarily for the free webinars. Because I'm going to try to do a free one or two free webinars a month and connect that to it. It's going to be trust me, y'all going ain't nobody going to be able to say anything to me about you didn't get what you paid for. I don't like to hear that at all. So, but anyway, let me get started. I gotta get started. I got people asking questions. Let's
I,
get started, okay? All right. All right. Let me see right here. It says, is authentication of the birth certificate a requirement to beginning the SBC process? What is the reason for people to get their birth certificate authenticated? I am not the person that created the authentication of the birth certificate. They came up with that. Let's talk about the authentication of the birth certificate. There were individuals who came up with something called Minnesota Rule 220. All right, general rule of practice, Minnesota Rule 220. All right, and that's it right here. Can everybody see the screen? Y'all can see my screen, right? Hoping everybody can see the screen. Well, anyway, you'll see right here this Rule 220. And it says the registrar of titles is authorized to receive for registration of memorials upon any outstanding certificate of title and official birth certificate pertaining to a registered owner named in said certificate of title showing the date of birth of said registered owner, providing there's attached to said birth certificate an affidavit of an affiant who states that he or she is familiar with the facts recited, stating that the party named in said birth certificate is the same party as one of the owners named in said certificate of title, and that thereafter the registrar of titles shall treat said registered owner as having attained the age of a majority at the date of 18 years after the date of birth shown by said certificate. Now, this is a rule of practice, that obscure rule of practice that somebody found that has absolutely nothing to do with anything that we're doing. Okay? This right here is a case of people not understanding the rules of English grammar and inability to read. We do have in our society today a lot of people who read something on their face and think it knows what it means. First of all, when I first saw it, I already knew that it's in a statute. They're not putting any private information in a statute. This is not a statute either. This is a rule of practice. But they're not putting anything in a statute. Okay? Private people don't use statutes, period. We have no need of them. We have no need of statutes. We use contracts. We use contracts first of all. All right, which it makes it idiotic for anyone to say what process isn't good, what doesn't work, or anything like that. That's just idiotic to me. It's like you don't understand private. Private is contract. You can do whatever you want as long as you don't violate a public law. You have the ability to contract unlimited. You can contract with anybody. You can contract with the federal. They contract with you all the time to get you to do what they want you to do. So are you saying that we can't contract with them to get them to do what we want them to do? That's basically what a lot of naysayers are saying to you, is because they speak to you in such a way that the government has authority over you and you have no authority at all, which is not the case. You got to understand jurisdiction and what your particular duties are on the private side and what their particular duties are on the public side. There is such thing as public rights doctrine. They have rights, but private people have rights as well. This is why you have in the Constitution, no private property shall be taken without due process of law, without just compensation. All right, that's a limitation on government. It prevents them from coming over into the private side. But as far as your question for the birth certificate, the secure party process has been around for 1,000 years without the authentication of the birth certificate. Tell me, do anybody see anything about authenticating the birth certificate and cracking the code? Did you see anything about it in any of those books? Okay. It's something that somebody else came up with. All right. And these people are reading this stuff. And I'm sitting here reading, and I'm like, this is not what this is even talking about. The Register of Titles is authorized to receive for registration of memorials. He can memorialize this upon any outstanding certificate of title. Outstanding certificate of title. The word outstanding is key. Something is owed on it. Okay, an official birth certificate. This outstanding certificate of title and birth certificate are two separate things. These people are reading this shit as if they are saying this is the same fucking thing. Now, this is what I mean when I say we have some illiteracy to deal with, some illiteracy issues to deal with. People not being able to read. Pertaining to a registered owner named in said certificate of title. This is a certificate of title. This is the birth certificate. They're not one and the same thing. A certificate of title is referring to something like land, a title to land, or a title to an automobile. Okay? This is talking about when you get down here, when it's talking about attaining the age of a majority of 18 years of age, when we talking about a certificate of title, we talking about a contract. Okay? Somebody, because it's outstanding, which means something is owed on it, and a person who is under the age of majority can't get involved in a contract. So it has to be held in the name of a custodian. And once that person reaches the age of 18 years of age, you have to bring that into court and demonstrate that. And they have rules of evidence that is for that. Okay, of presenting evidence in court. They want an authenticated birth certificate. A birth certificate that's not authenticated, if you bring it into court, it's hearsay evidence. It's hearsay evidence. All right, so you need two witnesses when you come to court. You need an authenticated birth certificate. When it's authenticated, that means that the principal of vital statistics has signed off on it, which is the Secretary of State. All right, the vital statistics is an agency. Okay, they're an agent. They need something from the principal, and that would be the Secretary of State who delegated the authority to them. So you need that principal to authenticate that for you, and then you need the custodian. He's going to come in with an affidavit as well and say, yes, this is that individual. This is him that's on this certificate of title. He's now of the age of majority, and now he can be treated as such. It's very simple. You know, they have 221 dealing with death certificates. And these are rules. I don't understand. This is a rule. This is not a law. This is a rule of court. Every court in the United States of America has the authority to create their own rules, and they just created their own rules for their court in presenting birth certificates as evidence in court. It's ridiculous. I did a whole video dedicated to it. Now, it doesn't hurt to authenticate the birth certificate. When you authenticate the birth certificate, when you go to birth certificate authentication, because people like to come on the scene and act like they the guru and everything everybody else did in the past was just garbage and everything. You know, it's like nothing's new. There isn't anything I haven't seen anything added to any of these processes as new. Not one damn thing. I've only seen people package it in a different package and put a different bow on it. But I haven't seen hardly anything new. When you go to birth certificate authentication, all right, and right here, Travel State Gov, you come to their website, and let's read this real quick. Authentication certificate requirements prior to submitting documents requiring authentication. Certain requirements must be met are as follows. All seals and signatures must be original, and all dates must follow in chronological order. And that's usually the case in all documents. I found that out when I was doing acceptance of deed documents at the clerk of court. They want the documents in a certain order, or they will reject them and will not tell you why. Will not tell you why. All documents that are in a foreign language must be accompanied with a certified notarized English translation. Let me shut this off because it keeps clicking. Okay, all documents that in a foreign language must be accompanied with a certified notarized English translation. Please submit a completed request of Authentication Service DS 4194 form with all your requests. In Section 4 of the DS 4194, the country of use for each document must be specified before the documents can be processed. And this is where people were saying Thailand because it was not a part of the Hague Convention. If it was part of the Hague Convention, that they were going to give you an apostille document. So right here, this is the document they already give you for the document. They tell you what to fill out. And in section 4, that's what they're interested in because that is what this is for. As you can see, the website that we are on is where? Travel State Gov. Okay? It's for traveling purposes. You're in a foreign jurisdiction. Okay, these are travel papers, is what you're putting together. What I suggest that people do is do an affidavit of identity with this. Okay, requirement for documents. Specific requirements must be met before the documents can be authenticated. But those requirements can vary depending on the type of documents requiring authentication services. Select the type of document below to determine specific requirements for authentication services. State and local documents. So right here we have birth certificates. Okay, what other requirements for state and local documents include? You must submit the original document that contains the raised or stamped seal of the court or Department of Vital Records. That's where you get it from Vital Records. A certified original, okay, and then certified by the Secretary of State in which the documents were recorded. The Secretary of State will certify to the official signing of the document under the seal of the state. The state is the principal. Vital Statistics is the agent. They not taking nothing from no agent. They want something from the principal. It's okay, yeah, this is our stuff. And then if you're traveling outside the United States, they don't want to see nothing. Another country don't want to see nothing from a state. They want to see something from the government, U.S. government. You go over into another country, they don't give a damn about you got something authenticated from the state of Texas, from the Secretary of State. They want to see something from the United States government. So this is what we have right here. Other documents that they have, they do affidavits also. They will authenticate affidavits. What are the requirements for an affidavit? I want you to think in terms of an affidavit of identity. Okay, requirements of general documents include acknowledgement by a notary public, so you have to get it notarized, certified by the clerk of court from the county in which the notary commissioned. Okay, so you got to get the note after the notary notarizes it, then you got to get the commission from the notary. That costs about $10. You get it at the county courthouse where the notary receives her commission, and then you want to get it certified by the Secretary of State from the state where the document was executed. All three of these are some very easy things to do. Okay. Item 2 may be omitted if authority in the item 3 will certify directly to the notary. All right, documents originating in the District of Columbia must be certified by the Secretary of the District of Columbia Notarial Section. All right, so right here, now they will authenticate that. You fill out this form like they said earlier, and you send it in, and they will authenticate it for you. Now, what is the reason for that? They said, well, they went into UCC and they said, well, yeah, an authenticated document is like an original. I can get with that. That's fine. Okay. But what does that mean? Okay. You're the registered owner of the certificate, meaning you are what? The beneficiary? Yeah, you are the beneficiary. If you have but authenticating the birth certificate is not, impacting that in any kind of way. But it doesn't hurt to have that done. It doesn't hurt to have that done. Anytime you get any documents authenticated, it is a good thing. It is a good thing. That's why I've never said anything against authenticating the birth certificate. It's actually a very good step. But the question was, do you have to get the birth certificate required to get it authenticated before you do the SPC process? And my answer is no. And I just gave you the reason for authenticating the birth certificate. I did a whole video on why people do this that I'm not going to go over again. But if you go to my website, and y'all can see I'm a big sports fan. I look at sports all day long. Okay, you got Minnesota Rule 220. You go over here. I explain all this in this video about Minnesota Rule 220 and authentication of the birth certificate. If you're new, I did a whole treatise on it. I wrote a paper on it. It is in your PDF section. Okay, it's called The Truth About Minnesota Rule 220. As a matter of fact, I'll take you over there and show you that right now on birth certificate authentication. If we go into our main dashboard, I think I put in a PDF section. On a secure party. All right, and did I put it in here? Let me see if I put it in here. Right here. What does Minnesota Rule 220 really mean? I wrote this paper right here, and then okay, okay, Latin for ignorance, excuse, okay. Okay, there's a movement that has escalated among the redemption circles of a process involving birth certificate authentication in order to become the registered owner of one's estate. This process is colloquially referred to as Minnesota Rule 220, which incorporated portions of the UCC in Article 4, Section 1 of the U.S. Constitution, which is the full faith and credit clause, but also termed the comity clause. Comity. Comity is the courtesy one jurisdiction gives by enforcing the laws of another jurisdiction. Comity is granted out of respect, deference, or friendship rather than as an obligation. This is what they were using to try to use Minnesota Rule 220 in other states. It's called the comity clause, but none of them study comity or what it actually means. They just think you can run in and get a rule of court from another jurisdiction and use it in any state you want. Patently false, utterly ridiculous, and people who do that, you look really circumspect. It's like it's crazy because people are looking at you and say, okay, can this person read? While I'm not opposed to authenticating the birth certificate for additional layers of security as it relates to travel purposes, the sheer absurdity of locating an obscure rule of practice in a foreign jurisdiction and attempting to compel clerks in other states to recognize it was astounding to me. I took some time to research Minnesota Practice Rule 220 regarding the birth certificate in order to determine if what the so-called gurus were saying was true or whether it was a misrepresentation that individuals took and ran with, a mistake. Mistakes are categorized as mistake of fact, mistake of law, or mutual mistake. A mistake of fact occurs when a person believes that a condition or event exists when it does not. A mistake of law is made by a person who has knowledge of the correct facts but is wrong about the legal consequences of an act or event. A mutual mistake arises when two or more parties have a shared intention that has been induced by a common misbelief. And then we have UCC 1-103, where it talks about mistake. Okay. Right down here, contract principle, mistake is a principle. The principle of law of equity. Okay. And then right here, you see mistake is included amongst those. Okay, first let's look at what a rule of practice is using Bouvier's 1856 dictionary. We quickly come up on the definition and see right there, we can see what a rule of practice is and what a rule of court, because a lot of these guys will run around calling it a rule of court. It's not a rule of court, it's a rule of practice. And a rule of practice is certain orders made by the courts for the purpose of regulating the practice of members of the bar and others. That's what it's for. Okay? And then I got into the definitions, and you can go through all of this. I'm not going to go through all this, but I have it on here, and I went in all into it, the age of majority. I got all the statutes, what a minor means, right here, case law that supports it. What is authentication? 901 requirements of authentication of identification is Rule 901. Rules of evidence, hearsay evidence. And this is what the Uniform Vital Statistics Act of Minnesota 1974, sections 144.151 to 144.204 and 144.49, which requires certain individuals to make reports to the State Board of Health concerning births, deaths, etc. Similarly, Minnesota Statutes 1974, section 517.10 requires the filing of marriage certificates. And it goes on, but at the end it says, however, not all statements included in such certificates are admissible. Now, this is under the hearsay rules, and this is why you put this in there, just because you have a statement in a document like a birth certificate doesn't make it real. It has to be authenticated for that particular court to receive it. In Minnesota, we want to see the birth certificate authenticated if you're going to bring this in here, okay, to prove that this individual is of the age of majority, which is the only thing he can use is the birth certificate. You can't use no driver's license or nothing like that. Okay, they want to see the birth certificate. They want to see when this person who is underage, who's now coming into the age of majority. Same thing when you go get a driver's license. They want to see your birth certificate first. Okay, these are the things they want to see. But in a court of law, where evidence is required to be under oath and so forth like that, they want it authenticated. This is where all this came from, a misinterpretation of a rule of evidence in Minnesota that gave birth to this authentication of the birth certificate. Now, I'm not opposed to authenticating the birth certificate. As I said, it's a good thing to authenticate any document. Any document that you get from government, you having it authenticated is a good thing. Authenticated documents are good. All authenticated documents are good. But as far as it and doing that, and all of a sudden you are the owner of something and everything, and the world has changed and the clouds have opened up and the sun is shining and all that, you get that out your mind. And don't put that on me because I'm not telling you that. Okay, I'm not going to tell you. I'm never going to tell you that whatever you do is going to be the end of it. Because at the end of the day, what all of this is predicated on is how much you understand what you're doing and how firm of a conviction that you have in what you are doing. Okay, those two elements come on an individual basis. Okay, do I have another question? I think I'm not going to stay on birth certificate authentication too much. We've been talking about birth certificate authentication for like damn 50 years. Talking about authenticating the birth certificate. I got videos out, everything. All right, let's go to the next one. Who else got a question? Somebody said it's been a while since I've been on here. Looking good. Love the trust resources. Is authenticating? Okay, yeah, good. Peace, brother. Do you only do 1 hour consults? Yep, that's it. $200 an hour. That's what I charge. Any advice on stipulation as to a warranty deed giving a property to a trust that severs the mortgage obligation from the home as collateral? Okay, first of all, I don't understand how you reach the conclusion that putting a property in trust severs the mortgage obligation. That is patently false. I don't know where that came from. A trust is a person. That's like saying that you transfer the house to me, the mortgage got severed. No, it didn't get severed. That obligation remains. That obligation remains. What you're talking about is a lien on that property. It's a cloud on title. Okay, you have to have that removed down at the county court's office, and in most jurisdictions, the only way you can have cloud on title removed is through some sort of court action. Or here in Georgia, they only allow attorneys to do it now because of what this lady was doing in the from 2010. Her name is Karen Tapper. Karen Tapper was here. She went to jail. This lady right here, Karen Tapper. Because y'all trying to get put in jail. This is Karen Tapper right here. Okay. Let's see. Right here. Karen Tapper indicted on mortgage rescue scheme. From about 2007 to about 2009, Karen Tappert offered by word of mouth a mortgage rescue service, but the way she rescued mortgages was by recording fraudulent deeds that purported to convey the property from the true title holder to an entity that she controlled. Does that sound like, the trust that y'all talking about doing? Isn't it good to have somebody on a webinar that has seen everything? It just goes to show how deep I've been into this. Somebody asked me a question, I'm like, okay, I know where you got that from. And you can see the stuff y'all thinking about doing, people doing way back in 2007, 2003, 2001. People come up with these bright ideas like they knew. And it's like, that shit is old as I don't know what. Tappert also engaged in a squatter scheme whereby she squatted on abandoned properties in which she had no ownership right. From in or around December 2009 to at least February 2010, Tappert found properties that had already been foreclosed upon and filed fraudulent deeds that purported to convey the property from the true title holder to an entity that she controlled. That entity could be a trust or anything. Tappert gained use of the property, and is she could either rented out the property or sold it. This conduct forms the basis for counts 4 of 6 and involves the following properties. Got the properties on here, and she had a reconveyance. She had some real good stuff. The only thing that where they was messing up on is that she was going in and actually changing the deed over to someone else. So I'm not really sure where people get this notion that putting a mortgage in a trust severs it. I've been hearing that for like the last 5 years, and it's never been true. That's the person on no trust law. It's interesting how these questions are framed. You know, it can frame with with like it's a fact that you file a mortgage in a trust, it severs the mortgage obligation. They ask the question, is that like that's a fact? No, it's not a fact. Uh, what do we got next? Y'all can study Terry. I have all Karen Tappert's documents. I'll put those up also so y'all can review them. I have all the documents she was using as well. So I'll make those available to you as well. Because you got to read these cases so you see what not to do. Because people tell y'all to do stuff because some people out there trying to get y'all arrested. Uh, let me see what else I got. It's about an adopted guy. I mean, well, no, what authenticated birth certificate? No, it's not about no adopted guy. Where do you see adopted in there? It's about you being under the age of majority. I haven't nothing to do with you being adopted. Where's there adopted in there anywhere? It's about being you either the age of majority or not. No one under 18 years old can enter into a contract. Doesn't matter if you're adopted or not. When you're in court for a criminal charge, no matter the charge, can you give them won't y'all raise y'all hand and ask these questions? I can open up your microphone. I can't open up your microphone. I'm tired. You know, I didn't get on here to read questions. Let me open up Philip. Who is this? Philip Williams. You have a question, Philip Williams? Can't open up his mic. Let me see. When you're in court for criminal charges, no matter the charge, can you give them the I am the holder in due course bill and accept it for value and return the charging instrument? I seem to see a lot of people arguing with the judge. I mean, what do you mean for a criminal charge? Yes, you can. If it's a criminal charge, you can give them that because all criminal charges are commercial. They're all the same. I think the more intelligent question would be, should you do it on every charge you're at? I think some people have to exercise discretion because a lot of traffic tickets are criminal charges. A traffic ticket is a criminal charge. Okay, but the thing about it is that do you want to do that on everything that you're doing? You know, because people tend to abuse processes and things like that. The next question I'd have to ask is, are you always in? If you're always in court, there's something wrong with you, something wrong with your mind. If you're constantly going to court, you're constantly getting traffic tickets, you're constantly getting arrested, then there is something wrong with you, and you probably should get locked up for a little while. If you keep on going into the court system and having confrontations with these people, there's something wrong with the predominant thoughts that you're carrying around every day. You're looking for a conflict or you're in some sort of conflict type mode. But the thing about it is yes, you can do that. You don't argue with the judge. Arguing is a traverse. When you argue something, then what you're doing is you are now subjecting something for a jury trial to make a determination. When you argue on something, that means there's a disagreement. And this is why you have in the Bible, it says, agree with your adversary while you're on the way to court. At least he hand you over to the judge hand you over to the bailiff, and the bailiff casts you into prison. I tell you, you will not come out until you pay the very last farthing. This whole system of the administrative process is based upon agreement of the parties. There has to be an agreement. That agreement is stipulation. In court, they call it a stipulation. Let's look at what stipulation is. Let's go to the website real quick and see if we can find out what a stipulation is real quick. Let's check out law dictionaries. See, I got a lot of law dictionaries on here for you. And I always like the eighth edition. Y'all know I like the eighth edition. It's broken up for you. S All right, and oops, what happened? Sorry about that. I clicked out of it. Hold on. Won't let me slide down on the side over here. I'm trying to slide it down. It won't let me slide. There you go. All right, you'll see right here, stipulation. All right, right here, stipulation. Let's blow it up. Stipulation, a material condition or requirement in an agreement. That's the definition right there. Semicolon, explanation, especially a factual representation that is incorporated into a contract as a term as a term, breach of stipulation regarding payment of taxes. All right. Let me read it again. A material condition or requirement in an agreement, especially a factual representation that is incorporated into a contract as a term. Okay, breach of stipulation regarding payment of taxes. Such a contractual term often appears in a section of the contract called representation and warranties. All right. A voluntary agreement between opposing parties concerning some relevant point. There's the definition, semicolon, especially an agreement relating to a proceeding made by attorneys representing adverse parties to the proceeding. The plaintiff and defendant entered into a stipulation on the issue of liability. This is the issue. All right, when you arguing, you are raising an issue. Okay, so if there is no stipulation between opposing parties on those particular facts of what the facts are, because facts have to appear in court. Okay, you don't facts are either stipulated to or they're argued over. If they are argued over, then you're going to a jury trial or a bench trial. If they are stipulated to, then once all the facts have been stipulated and there are no more issues, now we can go to law and the judge will make a determination and apply the law to the particular facts of the case. So when you do an administrative process, that is what you're doing. You are attempting to get an agreement, a stipulation. Okay, you before you go to court. Before you go to court. Hope that answers the question. Where are y'all asking these questions at? Let's see questions. Okay, what is this? Yeah, you have everything in order before you go to court. Yes, you do. You're supposed to. And I'm doing a video on y'all see the administrative process link. Y'all gonna have that tomorrow. I'm gonna finish that. I'm gonna probably finish that tonight. You go to the main dashboard right here. You see this? Where is it? Oh, right here, courses. Right here, this link right here. That's what I'm working on now. I'm gonna have that done for you. All right, the administrative process. All right, because everybody who does this needs to know. The problem is a lot of people don't know how to properly conduct an administrative process. That's why I'm kind of cutting everything short and doing this first, because really, even being a secure party is not good if you don't know how to do an administrative process. You got to know how to reach a stipulation between the parties and so forth, what the material facts are before you engage. It's a contract. Notice that they talked about in that definition contracts, like a term in a contract. When you draft your documentation, you're drafting a contract. It's all letters or contracts. All right. Let me go to the hands up real quick. Donald Carroll. Yeah,
Yes,
the mic is open.
can you hear me? Can you hear me?
I hear you loud and clear.
Okay, yes, sir. Peace to the gods. You. So I just want to first of all say, man, thank you for what you do, man. And when I found you and have found you now on the internet, man, I don't like to use the word addiction, because addiction can be a good thing too, man. I've been watching your stuff like every day, man, all day, like 8, 9 hours a day, brother. And I want to say, very well thought out, very detailed. I love the music that you have behind it. I mean, your YouTube, everything, brother. So keep doing what you're doing because you don't know, man, how much you reach out. And I'm right here in Georgia, and I want to keep it short. I don't want to take up much time, but a couple of things. One, I've been around this information since about uh in the late '90s, and I've been off and on. My problem was I got into it and I let somebody do something for me and not understanding it myself. So,
Right.
but to understand and say, brother, I don't learn like everybody else. And what I mean by that, and not putting myself down, I don't catch on to stuff quickly by reading. So I'm gonna learn by watching, playing back the video, taking notes. That's why it's so powerful what you're doing because people learn in different ways. You know.
Right, and that's why I'm doing the training videos, and I try to make them entertaining, because I understand that. You got to understand, I was locked up, and that taught me a lot because I was helping people with a lot of legal work, and I ran into a lot of brothers who couldn't read,
Yes, sir.
a lot of brothers who couldn't read, and
Struggle with
so
that.
I had to, one of them was a very good friend of mine, and we knew each other a year, and before I found out he couldn't read. I've been
Yes,
knowing
sir.
the brother for a year, and then one day he got some mail, some legal mail in. He can't say, man, what does this say? And I said, oh man, it just says right here. Can't see what this say. And he looked at me, and he didn't even have to say it.
Yeah.
The way he looked at me, I knew, and I didn't want to embarrass him. Oh yeah, man, it's saying this right here. But
Yeah.
I understood that is a barrier,
Yes.
and so I had to account for that. And
Yes.
so that's why I read everything too. You notice I'm not
Yep.
only putting up the words on there, I'm reading it to you and
Yes.
then explaining it and doing everything else too, because I understand that point. I understand that.
And so
And
just to say my point real quick before I let you go is that I'm here in Georgia. I kind of reached out to you on the web and let you know I'm a builder. I'm a black builder, man, and I build. So my goal, Yusuf, is to start buying land and start, I want to build Black Wall Street. I want us to go, man, and just start building our own communities from the ground up. Man, I got tradesmen, everybody ready to rock and roll, run and do this thing, but I want to get it to be the secure party like I should be and being able to conduct my business and handle my estate and just build commercial buildings, residential stuff, man. And I'm ready to find out and understand about credit, business credit. That was something that I'm privy to and understand. So I've been around this information,
I'm
man.
adding a section for that too. I'm
Yes,
adding
sir.
my business section going to come second after I get this established. This is what people don't understand about Secure Party. Secure Party teaches you how to do business. It's
Yes.
business. The
Yes,
UCC is
sir.
the Uniform Commercial Code.
Yes,
Okay.
sir.
It's the uniform. It teaches you how to sign documents. I can't begin to tell you how so much unrelated secure party business stuff I do. And just because I know what I know, it helps me in my other business transactions.
Yes.
Just educate. I can sit down and talk to a tax attorney now. I can sit down and talk to an attorney, any attorney. I can read a contract.
Yes, sir.
I can read a contract now. So my friend, he's in construction, and
Okay.
when he gets a contract for a new job, he brings it to me. He said,
Yes.
"Man, look at this contract for me real quick," and I can read it like it's second nature. I don't have to stop and look up terms or anything. I know what it's saying,
Wow.
and that's how it improves you as a business person too. So people need to look at it from that aspect. That's why I'm going to be adding a whole business section on here because you live in a commercial world. You either
Yes.
have a business or you work for somebody who does.
Yes, sir. Yes, sir. Well, brother, again, man, I appreciate the peace to the gods, man. Keep doing what you're doing, Yusuf. And I want to reach out to you. I want to get a chance to get a face to face with you. Reach out. I'm going to upgrade to your top package, man. Money ain't a problem. And get what I get because I got to get all this knowledge so I can understand, do for self, man. So I won't necessarily need you to do for myself,
Right, right. Yeah, I tried to. I had to kind of weigh the balance between the prices on doing the whole package, and I had to upgrade. I have to upgrade all my current members. They grandfathered in. I'm just grandfathering all them in because
Okay.
they've been riding with me since the beginning. But the thing is that and do the $25 a month and give you enough stuff in that as well. Make it affordable for people. And
Yeah.
I'm thinking about doing an upgrade, like after you in 6 months, it automatically. I got features on here where after you've been paying for 6 months, you can upgrade to another level. and
Right.
stuff like that too. So, it's things that I'm trying to make it for everybody where people can afford it and people can get access to all the information. I don't want people to feel like I'm leaving them out of something because they can afford something.
Yes, sir.
But I am trying to also, y'all got to understand the reason I do this. This allows me to do this all day. I hope y'all see that when y'all give me money, okay, y'all see what I do. I reinvest it back into you.
Yes, sir. I
You
see that.
know, I reinvest it back into you. I'm not going out, and just lavishly living and things like that. I reinvest it. I put in time. I put in work and doing all these things so you can have something and understand it. And you supporting me allows me the time to do that.
Yes, sir.
So that's what this is all about. So I hope people can see that and appreciate that as well.
And you
And
said,
thank you, brother.
and yes, sir. You said one other thing too. You said that you don't really get experience this until you've been into faced one of the black robes. You know what I mean? So I got a group of brothers, man. They've been in and they faced some black robes on time, and they've been doing this for about 20 years. And these brothers understand this information. So I'm kind of a liaison. Sometimes I like to put groups of people together because some of the people can bring information. Maybe they're the piece of the puzzle that just might be missing. You be like, man, brother.
If those brothers are as knowledgeable as you say, I welcome them to come in and teach some classes. I don't want to be the only person teaching classes.
Oh yeah, trust and believe these brothers are, man. They're very, very knowledgeable, brother. Very knowledgeable.
I'd love for them to come in and teach some classes and do some audios and some training tapes, and I'll compensate them.
Okay.
So, so the thing is like I am looking for other people who can do this as well because I can't do everything. But I'm
Right.
going to start allowing other people to come in, do webinars, do training videos, and things like that as well. And put together some stuff. Because I don't know everything. I'm very knowledgeable myself. I'm because I have experience and I've been doing it a long time. But man, there are levels to this stuff. There's
Oh yeah.
levels. People don't understand that. I haven't reached the highest level yet.
Oh yeah.
So there,
Brother,
there are levels to yeah, there are levels to it. That's what people don't understand. There's levels to this information, man. A lot of
oh yeah.
levels. And
Yes it
and
is.
then
And one got a book out there too called The Wealth of the Wicked.
a wealth of the wicked. I'm gonna look that up. Wealth of the wicked. I'm gonna write that down. Wealth of the wicked. Because I read everything. You tell me that,
Oh
I'm
yeah.
looking for
Yep.
it.
It's
I'm
on
looking
Amazon.
for
You'll see it on Amazon. It's out there though.
it. Okay. Okay.
Yeah,
But
but I appreciate you, man. Thank you so much. Peace to the guys, man, and keep doing what you do, brother. And definitely reach out. You got my email, man. I want to be able to get in touch with you.
all right, bro. And you best way to reach me though, man. I'm on the site all the time. You can hit me on the instant messenger or hit me on my message or the leave something. Y'all start leaving stuff. The instant message is okay, but try to leave something in the forum if it's not too private. Leave your messages here in the forum. Y'all need to be in the forum talking to each other because y'all ask something on instant messenger, it might scroll down. I'm not gonna scroll all the way down trying to read all the messages all the time. I
Oh yeah,
do check I do check in here. And
yeah,
I check in the topics and everything. I'll check them and everything. But it's so many people. I try to get to as much as I can. But between me working on the website, trying to answer questions, take telephone calls, I can't do it all. But I try to get to as much as I can. And if you ask me something and I feel it's very important, if I don't ask it, what I'll try to do is a video on it. So be looking for that too. Sometimes I may not answer your question directly, but I will answer it indirectly by making a video on it.
yes, sir. Appreciate you, brother. Thank you
Because
so
my
much.
goal, because the goal of anybody will tell you, the goal of doing this is make everything automated where you don't have to be doing everything yourself.
Yeah.
That's the goal. So you try to answer as many questions, have everybody's questions answered about anything. So questions are welcome, and I do, but I'm going to be making a video on just about anybody's concern. Okay. Hey, but thank you, brother. I
All
appreciate it.
right. Thank you.
I appreciate it. Next question. Let's see what we have here in the chat room. Can you share which remedy you experienced which was successfully for one who does not have to go to court? Well, first of all, I ain't been in court in years. I don't go to court. But if you want me to tell when I was going to court, was when I was fighting, first of all, for my freedom. Got that off of me. That took like 31 months. And I was learning how to do it. The next one is when I was doing foreclosures and I was discharging debt using a bill of exchange. Now my bill of exchange are filed. I just don't put it out there like that because you know people digging up stuff, trying to dig up stuff, but they're filed on me. You'll see right here. There used to be a video up of me for a very long time. Cobb County, Georgia. Cobb County man claims he can save your home from foreclosure. Let me blow this up for you. Now, I want you to look at the date on this. Here's the date. A Cobb County man claims he can save your home from foreclosure if you just sign your house over to him. I didn't come up with that. They just threw that on me. Then Joseph Jones III prints his own banknotes to pay off debt. Channel 2 Action News investigative reporter Jody Fleischer spoke with Jones outside of the homes he said he now owns. I was in a home and they showed up at the house. Channel 2 News. Fleischer, Jones asked, why would anyone willingly sign their house over to him? They said they don't know how to save it. I know how to save it. That's an easy answer. The banks are stealing, Jones said. Once again, this is 2010, 8 years ago. Fleischer found deeds for 13 homes in Clayton, Cobb, Fulton, Henry counties, where the homeowners appear to have signed their property over to Jones to try and avoid foreclosure. And reason why they were doing that is I was doing a 50% interest in the home because they signed the homes over to me because when this person owned an investment group and they wanted to see, like this question this person is asking me, that what I do, did it work? So they signed the home over to me, the one they gave me to live in, the one so right here they gave it to me. I went in. They said, okay, we're going to give you this house, and you take it into court. It was in foreclosure. I took it into court and won, and they were in court watching. When I came out of court, they all started signing their homes over to me, and I was winning until they called Channel 2 News on me. And what they did was, that was if y'all ever heard the story, I was doing a house in Fulton County, and a banker called me on a private line, and he said, "I see you trying to take down another one of our houses." And I said, "What house is that?" He told me the house. He said, "Well, if you go over there and mess with this house, I'm gonna put you in jail." And I said, "Well, it's too late. I already own it." And so the thing is they couldn't do anything to me because I had the deeds to the home. See, I wasn't doing what y'all doing and trying to make up deeds and things like this. I understood how to real estate invest. So I understood that when you own the deed, there's nothing that anybody can do to you. So I requested that they quit claim a 50% ownership of the deed to me, and then I signed another quit claim deed where I quit claimed it back over to them, and they held on to that. They didn't file it. So when I got rid of the debt on the home, they would pay me, and then they could go and file their quit claim deed because I didn't want anybody to think I was stealing their house from them. But they never gave me the entire house anyway. They just really just added me to the deed. They only gave me a 50% ownership interest in it. The reason they had to do that so I would have standing to come in court, okay? Because I don't own the home when I'm doing it. And the very first thing the judge asked me when I get in court, he said, "What standing do you have in here?" And I said, "I got title and I have possession." Because I was living in the house, I had possession and I had title because I was on the title. And I presented both of those in court, a quitclaim deed. So I didn't get arrested for any of that. It said Fleischer found 13 deeds in Clayton County, Cobb, Fulton, and Henry counties where the homeowners appear to have signed their properties over to Jones and trying to avoid foreclosure. What the banks are doing is called fraud, and what I'm charging them with, and that's how I'm taking these houses because they're stealing them from the American people, Jones said. Jones posted a deed in the window of an Ackworth home to show that he owns it because the bank kept stealing, changing the locks. In this home in Ackworth, I had all these homes all over the city, and I hadn't been checking on this home. It was a real nice home in Ackworth. And one day when I went to check on it, a real estate agent was there showing the property to someone. I came in, kicked her out, kicked the people out who were looking, and they called the sheriff on me. Sheriff came to the home. I showed him the deed, told him to remove the people from the property, and they had already done $20,000 of repairs on the home. They hadn't filed a foreclosure deed or anything into the records or anything like that, and I took that home. They fought me tooth and nail. This home right here was a real big incident because they fought me tooth and nail over this house right here. Really did. Once Jones gets the deeds from the homeowners, he prints his own promissory notes. They weren't promissory notes, they were bills of exchange, essentially a bank guarantee for a debt. Once payment is tendered, the debt is discharged, whether they accept it or not, Jones said. What's the difference in the Federal Reserve creating a $100 bill promissory note that you choose to use and me creating one, he added. Jones said it isn't counterfeiting because he isn't copying anything. He's creating his own debt relief and helping homeowners in the process. Everything I do is according to law, and if I'm doing anything and if I'm not doing anything according to law, then call the police and have them come arrest me, he said. Just last week, Rockdale County deputies arrested Princess and Ivan Taylor, who printed their own promissory notes to try to pay off their own mortgages. That was a real big case. That was a sovereign citizen case, and that's what she was doing. She was doing a sovereign citizen case, and she tried to pull me into that, but she couldn't because I did all my paperwork right. Last month, the Channel 2 investigation exposed an anti-government group called Sovereign Citizens who were caught deeding million-dollar mansions to themselves. And one of the guys who was doing this, who won his case, was the first guest on my show, and he won. He took him to court and won. Then moving, and he used the Bible the whole entire case. That's all he used as his defense, is the laws from the Bible. And I'll put that recording up on YouTube. That's the first interview I ever did on high frequency radio. Several are already under arrest. Jones said he's not a sovereign citizen, but he stayed in jail like I think 21 months. Several are already under arrest. Jones said he's not a sovereign citizen. Notice I was saying that way back in 2010. Nor is he still in houses. I'm not going to just come up with some half-baked scheme, walk into some vacant house, and just move in haphazardly. I'm going to do things the right way. This has nothing to do with sovereignty. It has everything to do with the law, banking, and fraud. Thursday evening, Jones faced representatives from Citibank and Fulton County courtroom as he tried to keep one of his properties. The judge ruled that the foreclosure can move forward. Jones has not been charged with a crime. However, police confirmed they are investigating. And what I did was, after this, when she came to my house, and this interview was about an hour long. You know, they only showed about 30 seconds of it. But me and her talked for about 1 hour. We talked a long time. As a matter of fact, when she came out to my house, I was on my way to court. And they came to the house, and I said, okay, well, I said, come to the courthouse. I was going to Fulton County. And she said, okay, I'll come down to the courthouse with you. They came to the court, and you see right here where it says I lost. It says Thursday evening, Jones faced representatives from Citibank. Citibank is gangster. I've never won a case with Citibank. They are gangster. That's the Rockefellers and all them guys. Okay, and they the ones that called me on the phone. These people contacted me and let me know they were gonna fuck me up on a private line. All right, and right here, when we went to the courthouse, she brought the television cameras into the court. The day before, I had read a document called Court Tricks and Traps. The day before I went into court, I read this document right here. And I learned how to make a objection and an exception. And I could go over the whole thing, what happened in court. I lost this case. I ended up losing this case. I took them to appeal. But the thing was, I was winning until they put me on the news. When I got put on the news, then everything I did, and that's what they do. What they do is the powers that be, they don't have to come and talk to you directly. They'll send their news team out and put you on the news, and they can study you from afar. They don't have to present themselves to you. Now, let me address what he just said, because one thing I get is, does this work in court? Don't ask me no motherfucking more. Do something work in court? Okay. You have to understand this. If you think these people are trying to recognize, you're going to force them to do the right thing. They're not doing anything for you. If you don't have the Constitution and you're weak, this is not for everybody. I cannot stand people who come to me and ask me that. Most of you who ask that question, you couldn't sit a damn week in jail to sit on something that you believe in. You looking for you to present some paperwork in court and instantly work. If you have that mindset, get the fuck off my webinar and do not ever come out your mouth again asking me to do something work. Because this type of process ain't even designed like that to work and don't work. It's individually based. And yes, I have a lot of evidence on stuff. I don't show it to you because I'm in the public. And most of the people out there, y'all ain't the type of people that needs to see everything. I'm showing you right here. It's an interview with me in 2010. That's 8 years ago. And I was already doing negotiable instruments and discharging debt. Out in there doing it. The stuff y'all talking about, a lot of stuff. Tons of stuff. Before I ever even came on a radio program. Let me show you something else. I'll give y'all a little something. If I got it, let me make sure I got it on this computer. Oh man, looking at. Hey, is that look over there? Is it a computer bag? Is it a computer bag over there? Oh no, it's not down here. I got that those hard drives. Let me see if it's on here. Um, because I was gonna put it. I'm gonna put it in. Oh yeah, I think it might be on here. Let me see. It's not on here. Hold on, y'all. Hold on for just a second. I'm gonna see if I can go get this. That's cool. You can always tell when I do a free webinar, it be people from the outside come in. That's why I get these type of questions. Yeah, but yo, how can you Mhm. talk if you don't have a phone on you? I can hear it. That's what I'm saying. Yeah. I can't hear it. Trolls only come to the free webinars. Let me see. I think I got this thing right here. What time is over? 11. Yeah. Let me plug this. Let me pull this document up real quick. I think I got it on here. Let me see if it's on this hard drive right here. Let's see. Yeah, okay. I think I got in this. What is the name of that case? Uh, Now I got to remember that client. What was that client's name? It was. Yeah, there it is right there. Let's see. Yeah, that's it right there. Let me see if I can find the case. Pull this case up. All right. Run the camera. All right. All right. Okay. Y'all can see the screen. All right. You can see this is like, and this was a case. This was an interesting case. Something I'm giving to y'all. This was an interesting case I was in 2010. There's civil file action number, and that's all the stuff that I filed in the court. This is all my filings right here. Statement of facts, and this is back when I used to write my own motions. All right, now I'll go through it with you. I wrote all of this myself. Okay, and let me see if I can stretch it out and make it smaller. Okay. Where is the yeah, there it is right there. All right. As you can see right here is one of those situations I've added myself to the deed and I made myself a part of the case. All right, because me and the owner were both on the deed. All right, so we're named in the caption of the pleading. It was against SunTrust Mortgage Incorporated, and they were trying to foreclose, and I actually stopped this foreclosure for a long time and tied up the court for a long time. I did an administrative process, answered the deed, answered the defendant's motion to dismiss and briefing. They moved this out of Paulding County to another county. Y'all can go and look it up. I'm giving it to y'all. Go and look it up. Now comes the plaintiff, Joseph Jones III, Mikhail Lee, proceeding appropriate persona, and hereby files this answer to the defendant's motion to dismiss and brief in support of complaint for quiet title and request for judicial review of administrative process. Plaintiff moves for an evidentiary hearing and for leave to take the discovery specified herein pursuant to OCGA section 91130, 91131. Plaintiff asked the court to take judicial notice of the fact that they appear without counsel, are not schooled in the law and legal procedures, and are not licensed to practice law. Therefore, the pleadings must be read and construed liberally. See Haynes versus Kernham. Some of you are probably familiar with that court case. Further, plaintiff believes this court has a responsibility and legal duty to protect any and all accused constitutional and statutory rights. I got that out of what did I get that out of? I think I got that out of abatement of common law. All right, statement of facts. All right. Oops, too small, 150. Okay, on May 17, 2010, the plaintiffs in this action tendered payment in the amount of $85,879.67 and $21,501.31 Exhibit A and B to SunTrust Mortgage Incorporated. The exhibits right here are the bills of exchange that I submitted to them. I put copies of them in the court case. The SunTrust Mortgage Corporation, the plaintiff hired the services of Tamar Lee, a notary located in Cobb County, to witness the commercial process and the tender of payment. Both payments were received by registered mail recipient at 10:30 a.m. on May 26, 2010 in Richmond, Virginia, 23224. I put my exhibit of when they received payment, which is the green card. And then also coming from off the post office. The defendant was given a memorandum of law and instructions to respond to plaintiff if tender payment had a defect and was unacceptable. Defendant has not responded to any of the plaintiff's correspondence, and as such silence can be interpreted as acquiescence according to Georgia law. Okay, and then I found the code in Georgia. In the ordinary course of business, when good faith requires an answer, it is the duty of the party receiving a letter from another to answer within a reasonable time. Otherwise, he's presumed to admit the propriety of the acts mentioned in the letter of his correspondent and adopt them. That's OCGA 24.423. OCGA 24.336 is acquiescence or silence. When the circumstances require an answer, a denial or other conduct may amount to an admission. The plaintiff in this action has secured the services of a notary public to serve as a witness to the transaction, but whose certificate of default may be only controverted by a jury trial. All right. All notary acts of notary publics. Okay, OCGA 24.723. All notary acts of notary public in relation to bills of exchange, drafts, and promissory notes required to be done by law may be proved by the certificate of such notary under his hand and seal, provided that such certificate is filed in the trial court at the first term. You need to know what a term of court is, are permitted to remain there until the trial. The defendant has been identified as the grantee and the foreclosing beneficiary in a trustee's deed upon sale. Thus, plaintiff denies that defendant's title has been duly perfected because the plaintiff is informed and believes and thereon alleges that the defendant has no records to establish ownership of the note or proof of his alleged security interest in plaintiff's property. And you got to understand, this is also, I'm the plaintiff in this. After I did my administrative process, I sued them. I'm not the defendant. I don't make threats I don't carry through. I told them I was going to sue them if they did not do what I told them to do. And after that 21 days, I sued their ass and took them into court. The plaintiff in this action unequivocally asserts that the tender of a certified copy of a deed under power is insufficient to establish standing in this matter. While OCGA 24.527 does allow a certified copy to be admitted as evidence, the defendant would still need to have the client to testify to the validity of the instrument and the contents contained therein. And then I give them another code, OCGA 25.527. A certified copy of a deed or other instrument affecting real property which has been properly recorded in the office of the clerk of the Superior Court of the county or counties in which said property is situated shall be admissible in evidence under the same rules which would apply to the original without the necessity of accounting for the original instrument. This principle, there's a principle contained in here that when they file something Okay, that's why they will accept filed copies, but filed copies are not original. Now in Georgia, they outline their stuff very well because right here it says, okay, you can bring a, copy in, and they won't account for the original. However, let's look at a couple of other things. OCGA 24525 outlines the existence of a genuine original, which qualifies OCGA 24527. The appellant in this action asserts that no original exists and that the defendant is not the true owner of the note and therefore has no standing in this matter. OCGA 24525. Okay, and then I give them that, which says the existence of a genuine original is essential to the admissibility of a copy. The amount of evidence to show such existence must vary with the circumstances of each case. Where no direct issue is made upon the fact, slight evidence shall be sufficient. This is the key right here when you're in a foreclosure. If you don't make a direct issue on that copy of that what they present in evidence, then what that today is called slight evidence, because these are maritime courts. In old times they used to call them half proof and full proof. Today they call it slight evidence, the slight evidence rule. Okay, so if you don't make a direct issue, that's the key word, direct issue, upon the fact, okay, meaning that you object to them admitting copies of documents into evidence, you have to object to it. And that's what you have the affidavit of forgery, and which they got rid of an affidavit of forgery after I discovered the affidavit of forgery. There was a case called Igana versus HSB. I'll give that to you right now. It's called Igana versus HSBC. I discovered this case in the law library. And right here, this is a dispossessory. Now, I want you to look at the principles in this for foreclosure actions. All right. Let me blow this up a little bit. And right here, you see, in this dispossessory case, Denard Igana appeals from the trial court's order granting HSBC Mortgage Corporation Incorporated a writ of possession to a piece of residential property located in Austell. Igana argues that the trial court entered in, number one, admitting the evidence, a security deed, which he claimed was fraudulent, without requiring HSBC to affirmatively prove the deed was genuine, and number two, refusing to allow him to cross-examine HSBC's counsel as to the securities deed genuineness. The admission of evidence lies in the sound discretion of the trial court. Okay, so they gave you some case law right here, and they do have discretion for the admission of evidence. Finding no abuse of discretion in the trial court's evidentiary ruling, we affirm. Okay, now watch why there was no abuse. The reason there is abuse is something that Igana didn't do. And the judge is going to tell you this. This is why I read case law, because the judges will tell you what you should have did. HSBC filed the underlying dispossessory action on or about December 6, 2007, claiming that it had purchased the property at a foreclosure sale and Igana was a tenant at sufferance. Igana filed an answer on or about December 18, 2007, asserting that he is the lawful owner of the property, denying HSBC's claim and asserting that HSBC's claim for a writ of possession was fraudulent. At a January 2008 bench trial of the case, HSBC tendered into evidence certified copies from the Cobb County Superior Court of a security deed Igana executed in favor of Mortgage Electronic Registration System. That's what they do. They're going to put in the evidence copies, certified copies of what your mortgage that you signed. This is when the mirrors stuff was going on real tough too. Okay, now you have a corporate assignment of mortgage to HSBC recorded December 18, 2007. A deed under power evidencing the foreclosure to HSBC recorded December 18, 2007. Igana testified that he never signed the security deed and claimed the deed was fraudulent, which is what you should do. All right. So let's look at what the judge says. Igana claims that once he testified that the security deed was a fraud, and this is what a lot of y'all think as soon as y'all say some shit, it's, that constitutes the matter. HSBC, so y'all start hollering at the judge saying that he's fraudulent and he's doing fraud. HSBC bore the burden of establishing that the deed was genuine. Igana claims that the HSBC failed to carry this burden and therefore the trial court erred in admitting the deed into evidence. We disagree. Okay. As an initial matter, we do not accept HSBC's contention that the issue of whether the security deed is genuine is irrelevant. Okay, so now the judges are going at HSBC because HSBC said that's irrelevant, and the judges say no, that's not true. It is relevant whether the deed is genuine or not, and they're going to tell you, they're going to explain it. The defense of a lack of a landlord-tenant relationship is a proper defense to a dispossessory action. I found this in the foreclosure bench book. Every state has a bench book. Okay, when you go to the landlord-tenant section, they will tell you the proper defense that these judges are supposed to have, because that is the book that the judges follow in landlord and dispossessory cases, or what y'all call unlawful detainer in some jurisdictions. Here we call it the dispossessory. In y'all areas, y'all call it unlawful detainer. We don't use the unlawful detainer here. We say dispossessory. And they pulled this case, but this case right here taught me a lot, because the number one thing that you have to claim in a dispossessory, that no landlord-tenant relationship exists. They're casting you in the form of a landlord-tenant relationship because you're a tenant at sufferance, okay, meaning that you are holding the property, and they're trying to kick you out because you're not you don't have title to the property. But you got to claim that that the relationship don't even exist. Okay, that is a key point that a lot of people mess up on, and it is something that is a principle. You're going to find this in every state. Just because this is now you can't use this court case right here because this is Georgia. This is from the Georgia Appeals Court. Okay, but trust me, that same case or that principle is enunciated somewhere in your state in another action. It says, thus, while claimed effects in the landlord's title, the premise cannot be raised as a defense in a disciplinary action. You cannot claim defects in the landlord's title in a dispossessory. All right. Igana's claim that he, not HSBC, owns the property is relevant to the extent that it challenges the allegations that HSBC owns the premises and that Igana is therefore a tenant at sufferance. Citations and punctuation omitted. Thus, the trial court correctly determined that it should consider the security deed insofar as it pertains to the issue of whether the landlord-tenant relationship existed between HSBC and Igana. Okay, now right here, we also find, as the trial court did, that HSBC established that the security deed was genuine by introducing a certified copy of that deed recorded in the Superior Court of Cobb County. Here go 44-223. A recorded deed shall be admitted in evidence. I just read that. I just read that to you. In my case, what I just read to you. Okay, a recorded deed shall be admitted into evidence in any court without further proof unless the maker of the deed, one of his heirs, or the opposing party in the action files an affidavit that the deed is a forgery to the best of his knowledge and belief. After I discovered this and started telling everybody this, they got rid of this law. You see, it's been taken out of the books. However, it doesn't matter, because when you put in an affidavit, it's a principle. All right. The principle of the affidavit of forgery still applies. I don't care if they did take the code section out. Okay. I put in an affidavit. I'm claiming it's a forgery. And they still got other codes to address that. Igana did not file an affidavit claiming that the security deed was a forgery. Igana submitted an affidavit attached to his answer in which he claimed that he had not entered into any security agreement with respect to the subject property, and the notice of foreclosure sale he received from HSBC's counsel was a scheme of artifice to assert a false claim against him and his property. This affidavit, however, neither references the security deed in favor of mortgage electronic registration systems nor asserts that the deed is forgery. He just told you the two things that need to be on there. It has to reference whoever is claiming, and you need to assert it's a forgery. Thus, we cannot construe the affidavit as an affidavit of forgery for purposes of OGCGA 44-223. In the absence of an affidavit of forgery, the security deed was properly admitted without further proof of its genuineness. And then they have another case that supports that as well. So this is what I do. I read case law, which helps me in turn when I start doing my actions. All right, is what I see right here. Plaintiffs in this action deny the authenticity of the certified copy of the note and claim a forgery. Plaintiffs demand that defendant produce the original note in order to have standing in this matter. Okay, plaintiffs have discharged the alleged obligation by tender of a negotiable instrument that was accepted by the defendants. Defendants agree that there is a court in satisfaction of the debt obligation. There is no controversy before this court as defendants are in default. OCGA 11-3311, a court in satisfaction. This is UCC 3-311, but I'm using Georgia code. A court in satisfaction Unless subsequent C of this code section applies, the claim is discharged if the person against whom the claim is asserted proves that the instrument or an accompanying written communication contain a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. All right, let me go next. And let me pause for a second and take some questions. Any questions real quick? Let me pause because I'll get to rolling. Let me pause real quick and answer some questions real quick. Raise your hand. You have a question. Siobhan Lashley.
Oh, blessings and good evening.
Good evening.
My questions is a little bit off of what you're talking about. So is it okay for me to ask you?
Go ahead and ask it, but no, it's not okay. But go ahead and ask it anyway. What is it? Because I'm gonna get back to this. What's your question?
All right. Well, I just want to thank you for the website. It is beautiful. One of them was a membership question. It was just basically when you upgrade your package, would that like cancel out the first one? That was just one of the main things I wanted to ask you from the beginning when I had my hands up. Also, me transitioning from, I guess what they call it, the public to the private. I do work a 9 to 5, and I listen to a lot of your videos and the things that you say. And one of the things that you was just going off about is like, don't be afraid to go to jail, this, that, and the third. Don't be afraid to stand up and be in court. And
Right.
I have experienced court, but more from the plaintiff side, tickets and fighting things like that. But learning a lot of things, in the last couple of months, I kind of shaped myself into kind of transitioning this into my everyday life. The things that you provide on your website, such as trust law, teaching you how to manage yourself in those capacities of owning businesses, would I still have to go the route of, contesting things and, if I actually take my time to go through it the right way? Because everybody don't want to sacrifice on those realms when it goes to
I
putting
understand.
you know what I'm saying? When you're trying to make it to
Okay. I got a
work
question
around
for you. Live an honorable life. Listen,
exactly.
I lived a dishonorable life. Nobody can tell me about honor and dishonor because I was a hustler. Okay. So I know the other side of the coin. All right. So the thing about it, which is a good thing, I'm glad I got both sides of it and everything. I know because I can see somebody a mile away what they about. I've been around people, I know the hearts of men. A lot of these cats would be talking and everything. You wouldn't survive two days in prison and everything. They don't need to be going. They don't need to be doing anything illegal. But the thing is that when you see that and you've gone and done what I have done, then you begin to understand, okay, what stand in honor means. Okay, what honoring the creator is. Okay, doing business the proper way. I file my taxes. I file my taxes. You know why? Because I'm doing business in the public. I'm taking Federal Reserve notes. I understand what I'm doing. There are a lot of people out there, they're operating under the illusion that they can use Federal Reserve notes without any type of kickback. Now, you have access because it is your credit they're using where you can violate things like 1099 and things like that and get all that back. But at the same time, there are procedures in the public that you have to follow. And most of these people that you're listening to are not business people. They're not. They're not business people. They're not businessmen. And they ain't trying to learn business either. They're not trying to learn trust or anything. And I had misconceptions about things at first too. My view on things has changed a little bit as I progressed on all of this that we're doing because I came through the door dealing with the criminal justice system. Now, anybody can say whatever they want. Criminal justice is the most corrupt thing on planet Earth. Ain't nothing right about the criminal justice system. Nothing. There's nothing, nobody can come on here and tell me about this not working and that. The reason it don't work because everybody in the criminal justice system is corrupt. The reason a lot of foreclosure stuff doesn't work because everybody dealing with foreclosures are corrupt. Because those are the two main things they're filing bonds on. Those are the two areas that you have to fight the hardest in. Is houses, because if they let y'all have y'all houses for free, I got videos I put up where the attorneys was telling you that they doing fraud. They got the notice. I was working with the attorneys. The attorneys came to me and told me we just got the word not to help anybody. That's why none of y'all can get help on an attorney no more. You in 2010, you could get help from an attorney with a foreclosure. A lot of attorneys were helping. I had the top attorney here in Georgia. He told me personally to my face. He said, we got the call. We can't help nobody no more with foreclosures. That came from the banks. The banks are behind all of this. I'm trying to tell you what it is. You don't have to believe me. The court ain't the problem. They just administrative courts. Okay,
So
that you're dealing with. So the thing is that you need to create an income for yourself, or because nothing is free. Okay, no, nobody's going to give you anything for free. Nobody's going to let deadbeats and bums come through the door and get access to black cards and things like that, not knowing what they're doing. This is why they have something called a sophisticated investor. You have to make over $300,000 a year or $400,000 a year if it's you and your wife. Okay, they're determining these different things. They're looking at, do you have an IRA account? Do you have stocks? Do you have things like this? Are you diversified in your investments? They're listening to how sophisticated you are. Okay. Most of these guys are trying to come through the door. They're not sophisticated in business. They just think they have some sort of entitlement right to something. This is about those trusts were created for the benefit for your benefit, but that benefit has to come through the United States and ensuring that their commercial world stays afloat and keeps going. So they're looking for you to do something, create some business, put people to work, create taxpayers and things like that. This is the whole game. And once you understand the whole game and everything, okay, you see what's going on. But they ain't just letting the average person just come through and just fly through. You know, I have to say, I've been saying that for like 5 years. It's like, man, you think they finna just open some door and let everybody walk through? You're crazy. That's why people be coming on these webinars and say this don't work and that don't work. Somebody ain't never been through nothing. They ain't looked in a judge's eye. They ain't looked in the judge's eye to see if it's the truth or not. They ain't sat down and talked to a judge. I didn't sit down and talk to judges.
I just wanted to, because exactly what
So
you
these are the things you have to say. They keeping secrets from you. It's a secret. Okay. They don't want anybody to know what's really going on. You have to use your deductive reasoning. So you asking me, will I have to keep going to court? If you have to keep going to court, I'll say it again. That's a problem with you because I ain't been back in court in about 5 years. It's been a long time since I've been in a court and everything because I do my business right. I conduct myself, I drive the speed limit. I don't speed. I got a couple of tickets. I ain't gonna lie. I got a couple of tickets in the last couple of years. All right. But they wasn't major, nothing like that. And when I got one in Louisiana, I took care of it. I just signed it. What I signed? I signed a coactus fee. I never heard nothing from them again. Never heard I signed the ticket. So the thing about it is you got to, and sometimes you don't want to fight every damn thing. Sometimes it's not worth it. These damn traffic tickets, they worth it, especially here in Georgia. I'm telling y'all right now, I will fight every damn traffic ticket I get in Georgia. I ain't letting shit go through. Nothing. I don't care if I was doing 120 miles an hour in a damn school zone. They arrested me. I'm fighting it. So that's just my stance on that. But some things you got to pick and choose your battle on what you're going to do. But as far as business, everything should be conducted through a business. Okay. You're getting a 4 or 5 number, and it don't have to be those numbers. It can be a variety of different things. But the thing is that everything is, you got to understand how the commercial world is set up. It's set up to operate through artificial entities. Everything in the public is an artificial entity. That's why they go by titles like Judge so and so. You don't see when you go to the Secretary of State's office and look at a judge's oath of office, it don't say Judge so and so nowhere on there. It has his name because that's a real person's name. Only a real living soul can be liable. Okay, in the public, he's not liable as long as he stays within the ambit of his delegated authority because he's an administrator. He's no different than a damn customer service rep at a damn corporation. They're exactly the same thing. Just like you can't sue a customer service rep, you can't sue the damn judge. He's an employee. You got to get the people who can bind the corporation, the CEO, the CFO. Those are the people buying the corporation. So the thing is that, it's like operate with the 4 rules. There is no money. Public and private don't mix. Stay in honor at all costs and do not participate in public controversy. Live your life honorably and off the radar as much as possible. When you study this trust manual, this is written by an attorney. He tells you all of this. The whole reason of getting a private trust is so people can't get in your business because the more people know about you, the more they can affect you.
Okay. Well, definitely. I'm definitely understanding what you're saying. I definitely stress that myself with the people that I study with is creating a degree of separation and understanding what you're doing before you go in and start filing papers, doing things. and make sure that you're doing things that apply to your life. But I have another question in regards to public and private. I've been hearing a lot about this equity side of the jail system, and
Right.
actually a side that can be accessed by a public individual.
Well, yeah. I mean, law and equity was merged. I mean, yeah, it's you can invoke equity. You do what's called a bill in equity.
Mm.
It's called a bill in equity. Let
And
me let me let me well, hold on before you go any further. Let me pull that up for you real quick. All right, you go to let's look at it. Let's not run through this. Let's look at everything I'm saying. Okay, on your website, I like to do everything from the website because I like y'all to uh find out where to find this stuff on the website. All right, right here in the dictionaries. I'm trying to remember if it's just under equity or if it's a bill in equity. I think it's under bill in equity. Let me see. Okay, let me. I ain't looked it up in a while. Right here, right here, bill. Wait a minute. Is this it? No, no. Is this it? I think this is it. When you look up equity, bill, and equity, it's going to redirect you here. All right, here. Yeah, it's also termed bill and chancellor, bill and right? Let me blow it up for you. All right, look at bill. A formal written complaint, such as a court paper requesting some specific action for reasons alleged. An equitable pleading by which a claimant brings a claim in a court of equity. Before merger of law and equity, bill and equity was analogous to a declaration in law. The nine parts of every equitable bill are, this is why I'm showing you this, the address to the person holding the great seal, number two, the introduction, which identifies the parties. Number three, the premise, which states the plaintiff's case. Number four, the confederating part, in which the defendants are charged with combination, which you're charging them with. Number five, the charging part, in which the plaintiff may try to overcome the defenses of the defendant that the defendants may allege. Number six, the jurisdictional clause showing the court's jurisdiction. Number seven, the interrogating part inserted to try to compel a full, complete answer. And number eight, the prayer. Anytime you always know something's equitable because it ends with a prayer, because equity becomes from the chancery courts, which is based off the church. So you'll see it in a prayer for relief. And number nine, the prayer for process to compel the defendants to appear and answer. So there are your 9 parts to a bill in equity. Also termed what? A bill in equity. Hello?
Yes, I'm still here. I'm listening. I was just actually like just taking down some notes, so that's good. Um, in regards to discharging charges, would you put anything specific on the website?
Yes, yeah, I'm going to do that. I got to get all this other stuff. That's what the administrative process is. I'm going to be doing because to discharge something, you have to do an administrative process first. You have to have a stipulation. You have to have agreements. You have to have facts that have been agreed to. You have to have your facts, all right? Because you have to have what's called an estoppel. Okay, they're stopped from trying to convert what you're saying because they already had an opportunity to do so before you got to court. So that's why I said equitable. Any equitable defenses that they try to raise, they're stopped from doing so because you've already established what the facts are in the case, and that is accomplished through an administrative process.
Okay. Well, I think I'll talk more in detail with you on a personal and when I upgrade my status on. Because I just have one more question, and you may like it.
I
With
can't
tax
hear you.
liens,
You don't have your mouth on the mic. Get on the mic. I didn't hear you. Repeat what
Oh,
you
can you?
said. Yeah, I can hear you now. Go
Okay.
ahead.
Oh, okay. I said last question. I know you may like it because you're into property. I'm into purchasing tax liens per se, and I want to learn how to connect it with a trust. So, would you be uploading information in regards to those type of
What do you mean tax lien?
subjects?
What do you mean tax lien?
Well,
Because in your secure party
per,
paperwork, tax liens are addressed in your
well,
secure party paperwork. It's a debt like
okay.
anything else.
Well, specific home tax liens, that's what I'm going into, foreclosure on home tax liens. So I wanted to learn how to do that through a trust. So that's why I want to learn about trust instead of opening it under my name. I'll be opening under the trust that creates residual, basically protect the income for generations, my further generations. So that's my
Yeah.
goal.
Yeah, I mean, a trust is a person. Okay, you got to look at a trust as just an invisible man
Another
walking
entity.
around. All right, and it can be sued. It has the capacity to sue and be sued like anything else. The liability part on it is going to be outlined in the indenture agreement as to whether the trustees are going to be liable or the corpus of the trust is going to be liable. Okay, that's outlined in the trust indenture agreement. However, uh, the administration of a trust to keep property in the trust, not subject to United States jurisdiction, is going to be heavily dependent on how you administer that trust. Putting it just by default, putting something in the trust doesn't automatically absolve it from liability because the IRS goes by what is called form versus substance. And I'm going to take a little time to talk about that because it's something that never most people don't understand it. I had talked to some guy on my website. He said, I took your trust course. It wasn't nothing. I asked him, I said, what is form versus substance? Form is the rights that we have. Substance, he said something. I said, man, you don't. So what are you talking about? You know what I'm saying? See what the IRS says. It's like, and this is what guys don't want to address. They just don't want to read law. They want to just do secure party and not really understand that in the public, you don't have no say so in the public. The public has rights. It's called public right doctrine. Okay. That's what you learn in this difference between public and private. Your job is to avoid paying taxes, not evade paying taxes. There's a difference in avoiding paying taxes and private people avoid paying taxes. Criminals evade paying taxes. They are acting in dishonor because they've incurred an obligation and now are trying to seek to get out of it. Now, I'm not saying you can't get out of it by not discharging it or presenting a negotiable instrument. That's not what I'm trying to imply. I'm trying to imply like ignoring or doing something like that. Those are all dishonorable things that you engage in or you feel like or arguing with them saying, I'm a private person, I don't have to pay no taxes. That's an argument I will never teach a student to do because I know how many people are in federal prison doing that argument. So why would I teach my people to do that argument when I know it sends you to prison, especially people who don't know how to defend themselves in court? All
Well,
right, so you have form versus substance. Oh, and let me do right there, IRS.
I remember you going over this topic a few times.
I
And
done went over it a whole bunch of times, and people need to, and people in trust really need to understand it because it is something that is going to be discussed heavily in the trust course. Form versus it's the basis of everything. I and there's been some cases where it's been rejected, but is more restrained. Let me see. Tax strategy is a more restrained use of substance over form now. Trend. Uh, Right here, it kind of explains that the substance over form doctrine has been the undoing of many otherwise legitimate tax strategies over the years. This doctrine looks to what a particular transaction or series of transactions accomplish rather than what the Internal Revenue Service has argued is most often a myopic reading of any particular provision of the tax code. A recent Sixth Circuit appellate court case, Summa Holdings, and you got to read these cases on form versus substance. I'm gonna break it down essentially as this: they're looking at the substance of your transactions. Obviously, if you have a trust, you have a 9(8) number, you're engaged in banking, you open up a bank account. Now you have transactions. Like a lot of people that I deal with, they were taught not to get a debit card. You don't need to leave basically a paper trail. Don't leave no paper trail. That's one way. You're having a paper trail because they're going to look at your transactions. Okay. What was your transactions? What did you engage in? Did you engage in a transaction that is effectively connected with a trade or business within the United States? If you've done so, there's going to be probably be a tax obligation that's going to be incurred from that. Okay. If you did not, and it doesn't matter if you have a trust, a 9(8) number, it doesn't matter if everybody that the beneficiaries are foreign, the trustees are foreign, the corpus is foreign, or anything like that. If you engage in a transaction because you're taking money out of the United States, and the tax occurs before it's put in the trust, on the income before it goes to the trust. And if you don't account for the taxes when it goes to the trust, they're going to tax it. They're going to either hold that trust liable or it's going to pass on to those beneficiaries, whoever the recipient is, on when that money is distributed.
Okay, so when they talk about opening a foreign trust and that's tax exempt,
It
that's
is by default. A foreign trust is tax exempt by default.
okay. So this one question that I really like to ask, I asked a few other gurus, and when you fill out on, I think is the WA bin, that's one, or you're indicating basically your foreign status, and you put any address in as a foreign status. How did you declare your foreign status when you're not actually
They didn't
foreign?
ask. They didn't ask for no address, and you're foreign. You are foreign to the United States. The United States is in Washington D.C.
Yes.
Okay. Now they try not to recognize that, but we all know that United States the United States is foreign to everybody. Okay, you got to understand who the United States is. Once again, this is one of those situations where they're lying to you and don't want to tell you the truth, and it is the crux of everything. When you look on these videos on YouTube and you see all these people talking about sovereign citizens and government, anti-government terrorists and different things like this, they will not address what we're saying. What we're saying is, okay, please define for us what United States is. There are three different definitions for United States. Okay, you have United States of America. United States is a corporation in Washington D.C. Okay, when we're talking about being foreign to something, or you're talking about coming out of something. That's what you're talking about coming out of. We ain't talking about the Republic of the United States of America. Okay, you were born here and you're attached to the land. You're a citizen with a capital C. When you look at the Constitution for the United States of America, prior to the 14th Amendment, everywhere you saw the word citizen, it was with a capital C. After that, the 14th Amendment, they changed it to a common noun. This allowed corporations to become citizens of the United States. They turned everybody into a corporate fiction because everything in the public operates through commerce. And if you want me to even go further with it, separation of powers dictates that Article 1, they don't have any judicial power. None. None. Okay, all they can do is administer everything that is within their delegation of authority, which is under Article 1, Section 8, which outlines the powers that have been delegated to them. Under Article 1, Section 8, Clause 3, they've been delegated the power to regulate commerce. Under Article 1, Section 8, Clause 9, they can make tribunals inferior to the Supreme Court. And in those courts, they adjudicate commercial matters because that's the only power they've been delegated to. And because of separation of powers, it prevents the judiciary from interfering with that, what they call political question doctrine. Now, you have to, the average person don't understand that. I understand all of it. That's why they don't come fuck with me about it, because I understand exactly what it is, because I can break it down and explain it in terms that they understand. And they can't start throwing them this sovereign citizen argument up in my face, because I'll break down the Constitution to you. I understand what separation of powers is. I know what political question doctrine is. I know what compelling public interest means. I understand what those things are. I know that the public has rights, but you don't have a right to infringe upon our right, because in that same Constitution, it tells you no private property shall be taken without just compensation and due process of law. And no contract. No law shall be created to infringe any contract law is private law. Both of those talking about the private. So your job is to learn how to be private, because that's where your rights are. Because you don't have no rights in the public. You got civil rights in the public. Something that they gave you, some sort of privilege. And understanding that demarcation line is the key to understanding any of this stuff we're talking about. Which is what I guess I should be talking about tonight, instead of trying to prove to everybody that I've been doing this for years and everything, because I'm always assaulted like this. and it's really interesting and everything because a lot of people, these other people they follow, we was all doing this shit back together back 8, 9, 10 years ago. A lot of these guys in these other groups and everything, I see these same people 8, 9, we know each other.
Well, listen, I'm not into that.
I
I'm
wasn't
into.
talking about you. I wasn't
Oh,
talking about you.
I
I
just
wasn't talking
wanted,
about
I definitely want to know, let you know that I'm applying what I learned to my real life, and I do have a little forum with, basically people who are professionals that want to learn and operate at a different capacity and learn how to manage their taxes and all this stuff. So all of this is to say that I'm grateful for the website. I'm grateful for you actually putting it together because that was one of the things that I was asking, like, can someone put a comprehensive website together? Well, basically, we could have modules to go over. So I do want to say thank you for that per se, and having something that we could focus on.
Yeah, you're welcome, and I understood that that is what needs to do, and that's why it's kind of taking me so long to do the videos, because I am being very meticulous with it and trying to do it step by step. Just adding each little module, breaking everything down into modules now, step by step, and trying not to make everything longer than 5 to 10 minutes long, because there is an attention factor that is related to it, and people like to go to just what they are interested in and what they want to know. They don't want to sit down and watch a 2 hour video. I just need the section. I need to understand this section right here. And so that's why I'm doing it like that, breaking it down into modules. And you're going to see it's a long way from completion, but you will have everything. I promise you. You'll
Well,
get everything.
I'm grateful, and I do stress the fact as well as you do is being diverse around, thinking and being able to defend yourself on certain aspects. And when I say I want to stay out of jail, I want to stay out of court, I do as much as possible, in whatever process that I feel I choose to use or anybody around me, they should just be very
It
well.
is, and that's my job to keep you out of jail. That's why, like, I don't teach you about liens, putting a lien on public official.
Yeah.
I know that too. But you don't ever see me talking about it because that is something that's going to get a lot of people arrested. And then it's going to fall back on me because Yusef told me to do this right. I'm like, nah, I don't do that. Let's make sure they understand public and private and everything first. And then we can get into liens and different things. But people don't understand that. See, people have this urgent need, right now. They need some help right now. Because like when people get involved in this, they need help now. They got a foreclosure, kid's been taken, got a court case or something like that. They don't really have time for 3 years to try to learn something, anything like that. And which is really what is required. That's almost like saying, you're gonna go you're gonna be a lawyer and then go to law school. Somebody say, hey, I need to represent myself, and the person you're going against just went 3 years in law school to study procedure, and then you're going to come in and try to fight him, and you've been studying procedure about 3 months or 1 week or 2 weeks or something like that. It doesn't make a lot of sense. So you got to, first of all, in a situations like that, the superior man stays within his own domain. You don't want to go into their domain, and that's another thing about these processes that people got to learn the nuances of not coming into their jurisdiction. There's a lot of things that can trip you up and get you in their jurisdiction. You could say something, you could do some sort of conduct, anything like that. That's something else that people don't understand. It is a very fine line when you walk, when you're trying to be private. And really, to tell you the truth, in my opinion, it's very difficult to be 100% completely private. You got to give it, but you can put your cell phone in a corporate name. You can put your car in a corporate name or trust. You can put all those things in a trust. All right. But at the end of the day, there's probably somewhere something may require some sort of interaction with you. I was watching Lindsey Williams, and he was discussing that the elite teach their children at 14. They start getting training on this. So I'm going up against somebody. I had this question with a law enforcement officer, and I said, who would win? A person who's been trained from birth to do something, or a genius? Who you think will win?
A person who was birthed to do something.
You've been trained from birth to do it, or a genius? Because what they do with our geniuses, they try to take our geniuses from us. But a genius would have a run for his money with somebody who's been trained from birth to do something.
Exactly. Because
You
it's
see what I'm saying? Even if,
training.
even if you are highly intelligent, you're dealing with people who've been trained from birth to do something. They've been trained all their life to do this.
Well, I want to do say thank you, and I don't want to hold up because I know you're holding the webinar. So I will be in contact, and I am in contact with a lot of different gurus, as you know. So I am grateful for all the information that's shared upon me. The overall
Right.
goal is to educate as much people as possible. And
And that's the whole point. And that's why I don't understand a lot of people. It's like they think it's like I'm trying to like teach people. I mean, my goal is not to try to teach you how to discharge debt. My number one goal is to spread awareness.
yep, and how to function exactly.
How it functions. That's my people understand that's not my goal. My goal is to spread awareness. And the reason it's to spread awareness is number one, I see how they can hide one person. One person can't do nothing. They'll hide you.
Exactly.
They
The
will
more,
hide you. And that's
yep.
what I mean when the people ain't down with them. They will hide you. Okay. So you have to understand who you dealing with. That's one of the 48 laws of power. Know with whom you deal.
Mm,
Okay, and understand what you're engaging in, and understand that numbers are required to do this as well. That now you are seeing that they are getting nervous about stuff because this information is spreading, so many people are finding out about it. The next step is to get the comprehension level up of the people, because so many people have been dumbed down in society. When you have something as simple as separation of powers that people don't understand, you don't understand civics, you don't understand how your government is set up. Okay, because a lot of the arguments that your pushbacks you're getting from the other side is predicated off the fact that they think everybody is stupid on this side and don't understand nothing.
and a lot of people are because everybody is really dumbed down. And
Exactly.
I'm not gonna go off. I could go off on my soapbox on that, but it takes people like us, just to take the time and actually break it down and just teach one person at a time. So that's why I say I'm very
That's
grateful.
why I'm doing the website, because I'm leaving everything I know on websites, and and step by step, and talk about every little point I can, and it's in a recording and you'll see it. So, so hey, and then people can judge it. You can grade me on it or whatever, but it's what the creator gave me. And I understand that the creator never presents you with anything that you can't. The thing about it is, whatever you're supposed to have, the creator is going to make sure you have it.
Hmm.
And I would not be doing what I'm doing and have so many people listening to me if in some kind of way the creator didn't mean for me to do what I'm doing.
There's many pathways to knowledge. It all ends to it leads to the same thing, the growth of self, which is most important.
It
You
is
know.
the most important thing. It is the most important thing. But okay, let me take a couple of more questions. I didn't get a chance to finish that court case. However, what I'll tell everybody what happened in the court case. What happened in this court case is they moved it to another county, and this lady ended up losing the house. Somebody was staying in it. They stopped paying. It was a whole bunch of stuff happened to it. But I tied the house up, and the judge wouldn't rule on it. It was a bill in equity. I wanted an equitable, uh, you know, uh, and this is like early. This was early. See, say plaintiffs in this action pray that the honorable judge issue a summary judgment confirming the default judgment entered against the defendant. The defendant's motion to dismiss be denied, and they didn't. They didn't grant them the motion to dismiss, and that the defendant be removed from title. Also, plaintiff is requesting that any derogatory information reported to plaintiff's credit bureaus be removed, and damages be awarded against the defendant in the amount of $50,000 plus costs, interest, and attorney fees and other just and equitable relief as this court deems proper. And I wrote this, and I filed it in court. And we went back and forth. I'm not going to show you everything. Let me see what I got right here. What was this? Here was all my certified mail numbers. I put his exhibits in. Let me see. Let me see what this is. This might be the letter. But this is the letter. I put the letters that I wrote. Loan number down here. And you see, in event of dishonor through non-performance and non-response was unintentional or due to reasonable neglect or impossibility. I'm attaching a copy of the same contract and payment instrument to this notice of non-response. Please, and notice I said non-response was reasonable neglect and impossibility. I'm giving them, this is an opportunity to cure. I'm attached. So I put all three steps in there. My first initial correspondence, my second, you can see right here what I did on May 17, 2010. You were sent an international bill of exchange, unicentric convention that under the law constitutes certified funds and may be treated as cash. The amount of the tendered instrument was $21,501, and I did two of them. IBO number, registered mail number, and was received by an agent at your location on May 26, 2010, as verified by return receipt. You have not returned this instrument with evidence of a defect from a qualified third party in the event of your dishonor. And I did this, and as soon as I got through with it, I sued them. I ain't played with them. All right. And the reason I'm kind of holding up on this because I'm putting this on the training video, and I really don't want to distribute it on a free webinar. This is going to be in the training video. I'm going to do all of this in the administrative process and the court action that I'm talking about. This I'm going to use this case as an example, okay? And it's going to be in the training video, so y'all are going to see the entire thing. Y'all got to see. And with this case right here is the reason I built my website and locked it down the way that I did because I don't want my information floating all over the internet. So this is why I'm doing it because now, as you can see, I had clients for days, and this is just one hard drive. I've been doing this for a very long time. These are all my clients and everything I have down through the years. These are the latest ones. I have hundreds of clients that I have worked with over the years. Hundreds. I have done many negotiable instruments to discharge debt. Not one, not two, a lot. Those 13 houses that you saw Jody Fleischer talking about, those were just the first 13. And I was being successful. That's why they put Channel News on me. I'm trying to tell you what it is. You don't have to believe nothing I'm saying. Okay, because what I'm saying ain't no way to prove it. We wasn't on YouTube. We wasn't doing YouTube. I ain't know nothing about YouTube. YouTube was in its infancy stage. Nobody was really on YouTube or nothing or doing social media. I think I had a Facebook account, but I wasn't using it or anything like that. We were in the street doing all the things that y'all want to do. Get cars, discharge houses, black cards, all this kind of stuff. We were in the street doing all of that stuff too. Heavier than y'all are because we had time. We didn't think about getting no job. Job was the last thing on our mind. We'll sleep on the floor in an abandoned house to do this. That's how we was getting down. So that's what I want people to understand and everything. When I come to y'all and when I tell y'all things and everything, it's not, I'm not coming at you selling you no pie in the sky. I don't want to give nobody the impression that this is easy. That's not the thing I'm going to do. I'm not going to give you the impression. I've been through it. I know it's not easy. I know it works. But I know that the failure rate is probably going to supersede compared to what's going out there. The failure rate is much more broad than the success rate. I understand that, but that doesn't mean it's not true. So let me ask a couple of more questions, and then I got to go. It's 11 o'clock, and I'm not going over time tonight because this is a free. Let me get Rashonda Caldwell in. Rashonda Caldwell. Hold on, let me open up your mic. Oh, you don't want to ask a question?
Hey,
Hey, what's up? What's happening?
can you hear me?
Yes, I can.
Awesome. How you doing? Peace be unto you, brother.
Peace, goddess. What's going on?
Okay, so I know you've been going off. Please don't go off on me. So my quick question is about equity. So I understand what equity is. It's basically is it basically fairness, right?
Fairness, impartiality, and even-handed dealing. The
Okay,
definition.
okay, so why would I want to waive equity in a court case?
I'm not saying you do. I'm not telling you to waive equity.
Oh, well, I'm just, okay. I'm sorry. I didn't mean that you would ask that you were saying that. I'm saying that maybe I should rephrase the question. Would I want to waive equity in a court case, like a traffic court case?
N- No, no, you don't. Equity. If you're gonna do a contract, which you do an administrative process, you're doing that in equity. You don't. You're trying to take them away from those statutes and take them in equity. And if you're using a trust, let me
Hmm.
show y'all something. Okay, let me show you. Let me show y'all something. Okay, let's just take care of this right now. Where is this at? Hold on. This is why it's so important to look up the definition of words. Have y'all noticed how many times I look up a word? Yeah, I ever
Yeah,
watch
I
my
have.
videos and notice how, and have you already noticed how I already know the definition of the word? It's not because I'm a super genius or anything like that. It's because I've been looking up words for years and I looked them up. My law dictionaries are my best friend. It's the first thing I go to. Okay. And I go to law
Yeah,
dictionaries and I'm going to look up the word because we're dealing with words. We're playing a word game. So the
right.
first thing is trust. Let's look up the definition of a trust.
Okay.
Now remember, you're a secure party is a UCC contract trust account, right? Right?
Right.
Okay. All right.
And I have a trust. It's not
Okay.
a one of
All
those
right.
foreign
Cool.
trusts.
All right. Cool. It don't matter. Any trust is good to have.
Yeah.
A private one is just better, but having a trust period is, whether it's a statutory or a private trust, a common law trust, they both, it's the best thing to have. If an attorney prepared you a living trust or something like that, it's going to be still a lot better than having nothing.
Right. Right.
Or and then probably the thing after that would probably be a will, but because we're talking about probate now, but
Yeah, they love to throw you in probate. They love that.
it's a probate is their biggest money maker. But
Yeah.
right here, if you look in, let's go to this, and yeah, here we go, right here, grantor trust, trust, express trust, effective trust. This trust was the second word the first word I ever looked up when I first opened up a Black's Law dictionary was the word legal fiction, an assumption that something is true even though it may be untrue, made especially in judicial reasoning to alter how legal rule operates. The second word I ever looked up in a Black's Law dictionary was the word trust. All right, enforceable solely in equity. Can you enforce the right of a trust anywhere else? Anywhere else?
Mm, not that I know of.
Well, what did the word just tell you? That? What do you mean you know of? What did it say right here?
It
What did
says
that just
solely in
say?
equity. Okay,
Okay,
so
solely in equity. So
enforceable
what does that
solely
mean?
in equity.
All right, okay,
Right.
so can you go anywhere else?
In fairness and partiality.
No, I'm just saying, can I? It says enforceable. So can I
Hmm.
enforce my trust in some other sphere of law other than equity?
Yeah.
No, no. Let me read that again. It says the right, comma, enforceable. What does the word solely mean? What does that mean? What does that
Oh,
word
it
mean?
means only. Only, Yusef. Only.
Enforceable only in what?
Equity.
So a trust is what? A trust is the right,
Right? Enforceable
enforceable solely in what?
in equity.
Okay. Do I need to say anything else?
No, 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 you don't. Okay, so all right, I get that. Now let me switch over a little bit, and I wanna ask you, what would you do in a situation? So let's say you got harassed. Matter of fact, listen, you talk about Louisiana a lot. I'm from Shreveport, right? So Lise Le Bon Ton Roulette. So I'm from Shreveport, and I was harassed basically by the Shreveport Police Department. Now I get you can't sue anybody in their capacity as they're working, but this
No,
last
you can't
time,
sue them if you can't sue them. Like if you got found innocent, you can sue, but you
yeah,
sue the state. You're
well,
suing the
see,
state. If you sue
I,
them in a public capacity, you're suing the state.
okay, so the way Shreveport does it, matter of fact, this is Caddo Parish. The way Caddo Parish does it is, it was moved from traffic. The first case was not. They couldn't win anyways because they arrested me for going to court. I was in court for a traffic ticket and I was arrested in court.
Right.
So I challenged the prosecutor that if I had to come back to that court, that would be a conflict of interest. And what they did was they moved it to district court. And so once they moved it to district court wouldn't touch it. They wouldn't touch it because of the paperwork that I had submitted to the city, which I was challenging the first ticket. So to get down to it, I got out of all of that. And district court said they wouldn't touch anything. They gave me a letter, said they wouldn't, we're not prosecuting you. So it doesn't look like a win on my behalf. It just looks like district court won't touch the case. And so,
That's what they do. They leave it in limbo. That case I was just showing you, they did the same thing with me. That's what
right,
them guys.
right.
You remember them guys? I remember you was listening to my show, but I put up an audio about you being the agent, and they going in there and they doing it. Guys went to court and they get a declaratory judgment and everything. And I'm like, I did all of that. I'm like, you think you're telling me something new? I said, people go in there and sit on shit. They ain't finna. When you get them, you got to know how to do like a writ of mandamus. Okay,
Right.
that requires a mandamus because if they will sit. This is what I mean. You got to understand all the tricks. Okay, because we have not been trained in procedure. We don't know how to move the court. You got to know how to move the court. So when the court freezes like that, you got to move them. One of the
Right.
ways you move them is you got to do a writ of mandamus. Because if that lower court has some duty that they're supposed to do, then that writ is from a higher court to a lower court that compels them to do what they're supposed to do. This is another thing people don't understand that you learn over time is that, yeah, they'll sit on it
Right.
because they can, because now they're sitting there and say, do you know how to move us? And most people don't. That's just
Right.
what it is. I'm trying to tell you, it's the game. They play on our lack of knowledge of rules of court. Rules of court. If you're gonna play on that playing field, you got to know the rules of court. You got to know. You got to know the rules of court. You
Yeah.
got to. You got
Yeah.
to know it because if you
I
don't,
have their,
they'll sit
I
on.
have,
They'll freeze up and not do nothing. Like that case I did in 2010, I didn't have as much knowledge as I have now. But I was writing papers and doing things like that, but I still didn't know a lot of courtroom procedure,
right.
that I had to learn over time and everything. And it's like, I made a lot of mistakes. I look at my paperwork now, I'm like, damn, I made a mistake and doing this and doing that. I look back on some things right now. I see all the mistakes I made. But the thing is that they will do that. You're not doing anything I haven't experienced before. When you get to, I had a judge. I'm gonna see if I can find this case. I had a judge. I took it all the way up to federal court. It was an administrative process, and the judge wrote back and said, um, gave me some one line thing because okay, the prosecutor wrote in her paper, I must not be allowed to win. I'm gonna find this and show it to you because it's in the court paperwork. I must not be allowed to win. This is how I had locked them down on an administrative process. And the judge wrote a one sentence decision denying me. And I fired back to get him recused. I said, what is this bullshit right here? And and then the clerk answered, not the judge, saying whether the judge is right or wrong, you don't have no right to recuse him. This I'm trying to tell you. It was the weirdest stuff ever. It was weird.
Wow.
I was like, what is this right here? It was weird. They will flip flop, and this is what I got to tell people. The reason I'm doing what I'm doing, I can make money doing my homeboys. Can I make money, man? Wasn't I making? How long you been knowing me, man? Come on the mic real quick. How long I been doing? Tell them something, man. This is my homeboy right here. Let him talk for a minute.
Hey, he a beast.
Now tell him, give him some
Oh, I
experience.
know.
He's been in court with me before, haven't you?
Hey, I've been knowing him 20 years, and he
Oh,
been doing this.
Well, tell him about the time we went in court that time. You've been in court with me. You've been in court with me a couple of times.
Hey, listen.
Tell him,
I wish you guys can come and really see him operate in person. That is like you talking about a college. You know how like people go to college? Now that would be a hell of a experience for you
yeah,
guys to just come and see him when he's like operating and talking to that judge, and that judge is like turning red.
yeah.
But the judge want to tell him, the judge really want to call him something else. Okay. But he can't. Okay. But yeah, he a beast though.
Yeah.
I appreciate it. I
Been
mean,
listening to him for a while.
he actually went in court with me a couple of times. Him and another partner of mine. I forgot about that. You sitting right here. You've been in court with me a couple of times. And how long was that? That was back in 2000 and what 2010, wasn't it? 2010, 2011, something like that. Yeah, that case right there. Yeah, that's what I was trying to tell him. I said before I ever start getting on the radio, we was doing all of this stuff right here. You know, that's what I don't think a lot of people can grasp is that I went through that little 5 year period where we was out there discharging dead, sending negotiable instruments to everybody. So when somebody say you get arrested, I'm like, man, I just sent about 100 negotiable instruments out. I ain't never got arrested. I'm saying, so somebody say that to me, I'm like, what are you talking about? I sent about 100 of these. I went into court with it. I presented those in court. I filed those negotiable instruments in court. I told Jody Fleischer when Jody Fleischer came to me, I took the negotiable instrument up and put it right on the judge's desk.
I mean, because I mean, come on, really, because they're not judges, right? We know
Say
that,
what?
I said, because we know that they're not judges. We know that this is administrative, and we know that they're flip flopping in court where they see all and hear nothing, and then vice versa.
Well, what the
You know,
thing is, I know where you heard that on my boy. Here's the thing. I'm gonna tell you what it is. They can't hear or see you unless you make an appearance. Okay.
right,
If you do not make an appearance, meaning that you don't do something in your conduct or action that subjects you to their jurisdiction, I've had that happen to me. I'm talking to the judge. The judge would ask me a question and I would ignore it and ask her a question. And she'd act like she didn't even hear me, start talking back. I've had that happen to me before. You know what I'm saying? Because if you don't give them, if you don't say something like answer to that name or even answering a question, okay,
mm-hmm.
it's called
I
making
agree.
an appearance. If you don't make an appearance, you ain't got jurisdiction. It's about appear. You got to appear. Every attorney has to file a notice of entry of appearance, but to be subjected to the jurisdiction of that court. And they don't have to necessarily file a notice of entry of appearance. A motion constitutes a notice of entry of appearance too. They just file a motion. And if you file a motion, that's a notice of entry of appearance.
Right, right,
So if you
right.
don't do any of those things, the thing is, if you ain't made an appearance, they can't see or hear you.
I agree. I agree. Well, thank you for taking my question. I listen, brother. I started doing this in 2014. Okay, I started doing it then, and I came in through the L Bay. That's where I
Right.
came in. But let me say this: I learned so much on how to study the law and where to look and and that's when it became obvious to me that something was wrong. So this happened for me in 2014. I did a ton of stuff and won a case or two down there, but it's a struggle. It's a struggle trying to stay
Everybody,
out of
anybody,
contract.
this is why so many people listen to me because no matter what a naysayer says, the people who know, and they can
Yeah,
hear. You know what I'm saying? It's like, look, man, I read these law books every day. I know this is what it is. Well, that doesn't work in court. Well, it's not because it's not true.
that's right.
It's
That's
not
right.
because it's not true. This is what they tell you. They give you the impression because something didn't work in court makes it
That
not
doesn't
true.
work.
Where do you
Right.
get that line of reasoning from? I mean, that is illogical. Okay,
Mm,
it mean couldn't a possibility mean that somebody's corrupt?
mm.
Oh, that's not possible, huh? So that lets me know they ain't never been in court, ain't been
That's
in, and
right.
that's why they used to tell us you ain't a sovereign until you've been in front of a judge. You
That's
don't know
right.
what's going on. All right. That's what it is. You don't know what's going on. So you need to
I'm
sit
telling
down
you,
and shut up because you don't know
them
what's
lights
going
is
on.
hot. Them lights is hot in that courtroom when everybody's looking at you when you're talking. So I'm telling you, especially when you don't know what you're doing. So
Yeah. Well, people
yeah,
try to make you look out to be crazy. And that's why you have to really, really,
that's right.
that's why you have to really, really be knowledgeable and know how to ask questions. Like, for instance, you always have to develop the technique of asking questions. When
Right.
somebody says, like this guy asked me today, he's talking about this is crazy, whatever. I say, look, if this guy is on this video, you tell me right now, is this an Article 1 court or Article 3 court? If you tell me right now this is an Article 3 court, I will agree with everything that you're saying.
Mm,
So you have to hit them when they start talking like that, hit them with a question. Okay, it's
mm-hmm.
like, hey, look, I'm crazy. But I want you to tell me right now, under oath, I want you to sign an affidavit. Tell me right now, is this an Article 3 court? Are we operating under what kind of court are we in? You tell me that right now and sign an affidavit under penalty of perjury or something like that. I will agree with what you're saying. But they not
Right.
going to do that. The
Yeah.
banks won't do it. They never going to attest to anything under penalty of perjury. And that is what you have to understand. Anybody can say anything in the street. It don't
That's right.
matter.
Right.
Put them under that, under God. Put them under
Yeah.
that, put them under that natural law. Because them words, I'm telling you, those words have consequences. And
Yeah.
they know it. They
Mm.
know it. Them words have consequences. And that's what experience teaches you from being in court. They be talking that mess, but if you take them somewhere where it's like, okay, well, I see this playing ground. This is your playing field. Let's go over here and let's see if you want to still play that same game that y'all playing right now. This hide the shell game and everything that
Right.
you're doing. Okay. Because they're going to play that game with you. And that is the challenge in teaching people all of this, because some of the questions I get are direct. And that's why I'll go off on a person. I'm like, look, man, like somebody asks you, show me an example of this working for you. I'm like, nigga, they not gonna put nothing in the public record showing you won.
Right. They sure not.
That's the first thing that you learn. Even in the federal case, even if you don't use this, I'm gonna tell you my best case that I found. I had to go into Pacer under the foreclosure cases, and when you got them banks on the ropes, they settle it out of court.
Yeah.
Those are
Quickly.
those are the pleadings that you get. You get the pleadings where they settle out of court.
Court.
Those are the
Yeah.
pleadings you copy down. They ain't nothing. They ain't letting nothing go on the public record. So when somebody
Yeah.
asks me that, I'm like, man, you don't understand what you in, bro.
Right.
You don't
And
know
we
what's
can
going
try.
on. You don't
And
know
we
what's
can
going
try.
on. You ain't been doing
I
this
agree.
long enough. You need to sit down, be quiet. Don't ask no question about something working or not. Get a little knowledge under your belt, and see what playing field you own and how the game go. You ain't got no rules to the game yet. You don't even know how the game is going. And you asking, all you worried about is in game. Can I win and
Mm.
nothing like that? Forget the knowledge. Okay, I'll tell you right now, it don't work. You can leave now. It don't
I
work.
know. Right.
You can leave now. You can
Especially
leave
since
now.
you
It
don't
don't
know
work.
how to
You can leave
enforce
now. You can leave now. Okay, it don't work. You can leave.
it.
You don't have to
Right.
ask me no more questions or nothing. Your curiosity has been satisfied. But they want to know if I've been successful. If
Mm.
I've been successful. I I fought in court. I had a lot of unsuccessful, but what made me popular was my successes.
That's
That's
right.
what I'm saying. That's what made me popular. But when I hit that news channel and that's why I'm doing teaching and everything. Because that I got on the news, that's what everything started turning for me. Is when they put me on Channel 2 News.
Mm.
So that's what happened, everything. Because they started, like all the banks, they started queuing in on me. I told a story. I went out there in Cobb County that he told me, look, everybody here knows you. Y'all just don't know it, man. That's just what it is. It's like y'all just hearing me teach and everything. But back in them days of the wild, wild west, when we were doing this and everything, that was like the wild, wild west before it hit the internet and it's become some sort of it became some sort of I don't know, with all the videos on YouTube, there's so many people talking about it. You didn't have nothing like that back in the day. Now
Right.
it seems it's been trivialized. I guess that's the word I'm looking for. Or being you got people saying it's crazy on such a higher scale, and a lot of things don't work anymore that used to work. It used to work when you would go into court and didn't answer to the name. That worked at first. But what the judges do, they'll do like they do in the NBA. They get they make what's called adjustments, defensive adjustments and everything. They make a defensive adjustment and they come back, and that's what guys don't understand. A lot of stuff that used to work may not work no more because they make defensive adjustments. So you got to be coming up with new stuff and everything, but the principle remains the same. They're gonna
Right.
they'll hit you with something like because they're always figuring out ways to get you too. Just like how you thinking about what to say in court and all of this, they on their side think, okay, if he come in and say this, how we gonna handle that if he say this? And they get together and do a brain trust and figure out how to trick you into something.
Mhm. Mhm.
It's the same thing I'm trying to tell you, and that's the game that's being played. And the people who don't have no experience, they looking for this evidence that it's like that's not how this is. The evidence is when you go into court, you look in people's faces and you see how
That's
people act. That's
Yeah.
going to be your first evidence right there. When you start seeing how people respond to you and everything, and you're going to be asking yourself the question, damn, I just asked them what jurisdiction they operating under. Why they try to put handcuffs on me and give me a contempt of court charge? I just came here, I just came to court. You know what I'm saying? I just came to court. I should say, yeah, you know
Pissed
what I'm
him off
saying?
real fast.
I've been arrested in court. You know what I'm saying? You know what I'm saying? So, yeah, I said, I come in and say, I said, well, look, I just want to know what jurisdiction you're operating on. The next thing you know, you got two officers standing next to you and everything. You're like, what, like, what did I do? And that's when you know something is going on. That's
Yep.
when you know, because and they can't talk about this. Like, damn, I didn't do nothing. I just asked a question.
Yeah, but that question is the key to unlock so too many doors,
If you
baby.
go
So
to an
they can't.
attorney right now and you ask him the question, if you go in there and because I asked this to an attorney, what he'll probably tell you if you go to an attorney and say, if I go into court and say, the Constitution of the United States of America only grants this court two criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract in the criminal aspects of a colorable admiralty jurisdiction. And ask the judge under which two jurisdictions is he operating under. That attorney is probably going to tell you the judge is going to give you a contempt charge.
Mhm.
And you have to stop and ask your question, why is that contempt? It's contempt because you are not accepting the charges. It's contumacious conduct by exposing the court. And this is what is talked about in maritime admiralty. If you ever study it and everything, they didn't call it contempt back then. They call it contumacy.
Mhm.
I'll give you the word right now. It's called contumacy is the name of the word. So you look right here.
How you spell that?
I'm going to give it to you right now. I'm going to put it on screen for you.
Okay.
So y'all know what it is. Hey, what is this thing doing? Hold on, I'm having trouble with this mouse right now.
Take time.
All right, there you go. Let's see. What is it? Contumacy, contumacy. TU.
You may see why.
Yeah, right here. Where's it at? Oh, no, wait a minute, hold on.
I found it too.
You found it? What does it say? Read it.
It says contumacy, stubborn refusal to obey or comply with authority, especially a court order or summons.
Keep reading.
Okay, hold on. I'm sorry. I just was looking at the front page. Okay.
Tell me what the other words. What else is it called? Here it is, right here. All right, right here. Court contempt of court. The refusal of a person to follow court's order or direction. See contempt. Contempt of court. This right here is the word they use when you look in the old books. They didn't use this book. They use when you look in the old when they and like in England and stuff like this. This is words you're gonna see when you look at maritime admiralty. They're gonna be talking about contumacy, and it
Mhm.
means contempt of court. Or right here, contumacious. Right here, I just said contumacious conduct. Right here. And a contumax is a person found in contempt of court. A person who's accused of a crime but refuses to appear and answer the charge. Right here, you're refusing to. And what are you doing in an admiralty court when you start challenging jurisdiction? What are you doing? You're refusing to what?
Refusing to answer to the charge.
You're refusing to appear, and that's what
Or
they call.
refusing to appear, right.
That's what they call contumacy or contempt. All right, here, contumacious conduct. Right here, contumacious conduct. It's what it is. Everything in there is based off of contempt.
Right.
It's contempt, and that is what is happening in maritime admiralty, and that is really a subject that everybody needs to study. Is contempt of court, as far as it relates to maritime admiralty jurisdiction. Something very important for people to understand, and it's a lot. I'm just going to tell you, it's a lot. It's a lot. It's a lot, but I'm gonna do video. I'm gonna do as many videos as I can, and hopefully, like the gentleman earlier, we can bring in some other people and let them do videos too. I'm not opposed to that. It's some other individuals out there that are beast. People was doing it before me.
Mhm.
Beasting. There's people been doing this a lot longer than me. A lot
Right.
longer than me. You know what I'm saying? That the guy. Well, number one, two guys that taught me. There were two guys who introduced me to this, and they had been doing it for shit. I think when I met him, he had been doing it 8 years. The guy who really kind of exposed me to a lot of stuff, he had been doing like 8 years when I met him, and he already did all his court. He was when I met him, he was at where I'm at now. He'd already been through all his court, did all stuff, and he was just chilling and everything. He had been through everything, and he meet me, and I'm at the beginning. And after about 3 years, he told me, he's like, man, he said, you think you know this, man? He said, now I'd been doing it about 2 years. He said, man, it take 3 years just to be functionally literate with this stuff. You think because you got 2 years in, you smart? He told me that. Yeah, I never forget that. He's all, and he's them were the ones that told me back in old school. He said, man, you ain't no sovereign, because they were using sovereign a lot back then.
Right.
People afraid to use it today. They're afraid because they coined that phrase. See, people were saying sovereign, and then they coined that phrase sovereign citizen. That word sovereign citizen is not that new of a term. It's a
Right.
coined phrase. But everybody was calling themselves sovereign for the longest. And then they came up with that. They made that term sovereign citizen and put it in a negative context and started making fun of people with it. And everybody wanted to stay away from it. And that's why I tell people use the word private, because it's the same thing. They ain't going to make fun of private. They don't make fun of that word because it's in too many of the law books. It's in too
Right.
many of the law books. They ain't gonna make fun of that word. So you just say, you private.
Yeah. They like to ignore you or laugh at you and make it seem like you crazy though, because that's what the officer called me in court when he arrested me. He said, "Oh, you're one of them sovereign citizens," and I told him I never said anything about being either
So
one of
you have
those.
to answer to that, and you got to be careful about answering questions.
Mm,
All you say is, I'm a citizen of the republic, and I'm an American citizen of the republic. I was born here, and I'm a part
right.
of the land. Okay, and you are a
Right.
public servant. I'm gonna tell you what they don't like is when you call them they face public servant.
That's why
You
he
know,
arrested me, because
you
that's
ask
what I called him.
you
That's
ask
what
them,
I called
they
him.
get mad when you call them public servants. That's something else.
Yeah, yeah, he
I
got
asked the
mad.
judge that. I asked the judge, I said, well, sir, aren't you a public servant? Yeah, ask him that. Ask him that. You're a public servant, man. What are you talking about?
I'm telling you,
Don't forget your place and everything, because you get a little out of place because you're restrained by the Constitution of this state and the Constitution for the United States of America. You receive the delegation of authority from the legislature for only a certain group of things that you can enforce that are commercially related.
Mm, all right.
Talk to them like you got some intelligence and you know what you're talking about. I had an officer tell me one time, because I went into the court and got into it with a judge, and they called the sheriffs on me. And he
Yeah.
meet me outside. He said, "What's wrong with you? Why you going in there off on the judge like that?" He said, "The judge can do what he wants to do." And I said, "No, he can't." I said, "No, the judge can't do what he wants to do." I said, the judge has a bond, and I can go file a claim with risk management and make him uninsurable for public service, just like you got a bond. And he said, how you know that? He said, not many people know that. I said, a lot of people don't know their constitutional rights either. All right. So the thing is that they will tell you anything. They will see this thing you got to understand about the public. They will tell you any. Let's look at the medical industry. They will tell you that medicine is good for you. You know what I'm saying? They will tell you that you need a what is the little shot thing, flu shots and things like that. They will tell
Yeah,
you. Don't think that goes on in the legal profession too?
I know it does.
Okay, they'll tell you anything. I'm trying to tell you. You got to get away from that, allowing people to, if somebody says something to me, I say, sir, if they say, well, you're a sovereign citizen, could you please define that word for me and tell me what legal authority you derive that word from so I can go and look it up for myself?
Right.
See, ask them questions to make them look stupid. The person asking the questions is always in control.
Yeah.
He's the dominant person. You know what I'm saying? So you ask them a question. I don't be trying to answer questions and say, okay, well, you call me a sovereign citizen. They say, I haven't been able to find that in any legal reference. Could you please identify the legal reference or statute, code, rule, or regulation that you have found that particular word that you choose to label me as and give me some sort of status as a public servant, mind you, here to serve me? I
Right.
probably throw that in there to jab them a little bit. But you
Well,
ask questions, you know what I'm saying? Just come off the top of your head. Get good at coming off the top of your head with responses that are intelligent, that are probing, and that ask questions. Hey, look, y'all, I gotta go. It's 11:30. I'm sorry.
thank
I
you,
will do.
Yusef. I'm so sorry.
That's okay. I'm having another webinar tomorrow. It is for paid members only. So all you trolls, keep your ass out. Okay, or pay
Thanks,
$25.
brother. Peace.
Come
Okay.
on in. I like to make the trolls pay. If you gonna come troll me, I'm gonna make you pay now. I'm gonna make you pay. I'm gonna make you pay the troll now. You gonna pay the you gonna pay the toll to troll. All right, y'all. I gotta go. I'll be back on tomorrow. Be looking for some videos. We'll be back tomorrow. Peace. I'm out. Peace. Hey, Joe, it'd be good to see some of those pictures of those people.